ICCPR Article 125, 26, and 27. This is the start of this session. Please pay attention to your speed to facilitate interpretation. Please also identify your affiliation, and please also remember to switch off your microphone after your speech. Thank you.
Everybody, to this first meeting of the Committee on Civil and Political Rights, as we just heard this morning, will be on Articles 125, 26, and 27, which means, in particular, on the one hand, the right to self-determination and minority protection, which in Taiwan is very much linked to the rights of indigenous peoples. And then the second main topic is the right to equality and non-discrimination, in particular the equality between women and men. So those are the main areas. There might also be the questions of Article 4 and 5 were so far in the report of the government. There was no mentioning of any emergency, but perhaps we could also take that up shortly, whether there are any plans and what would be the legal framework for that. But let's start with Articles 1 and 27. And in that respect, I will pass the floor on to my colleague, Ruka Sombulingi. You have the floor.
Ya, selamat pagi, good morning, kure sumanga. First of all, I would like to say good morning to all of my colleagues here and review committee, and also the distinguished delegates from our government. Thank you very much for today, and we start. I see smiles along the way, and also so let's hope for the best that we can maximize the time. The particular issues today we are going to touch. I'm going to lead on discussions about indigenous peoples. But before, I would like to highlight some of the already existing legal framework for indigenous peoples in Taiwan. And we are not new to this, but I think it's good to remind ourselves again that first, in 2000, we have the constitutional amendment to ensure that indigenous representation and cultural rights. Please correct me if I'm wrong. And then we have the Status Act for Indigenous Peoples in 2001, in the following years. And this act deals with identity, recognition, and status of indigenous peoples. And we also have a Name Act in 2003. So it's actually 2000, 2001, 2003. It's all good years that allows indigenous peoples to register original names in Chinese character with Romanized annotation. So we talked about language yesterday. There's already actually opportunity open for indigenous peoples to register their own name. And then Education Act for Indigenous Peoples in 2004 address indigenous specific education needs. We already heard about this yesterday from the Ministry of Education. And then we have the Indigenous Peoples Basic Law in 2005, Foundations Act recognizing indigenous peoples' rights to autonomy, self-rule in their territory, guaranteeing funds for language, culture, plus mandating consultations on land use. Yeah, which this we will touch on later. And then we have also Indigenous Languages Development Act in 2017, focus on preserving and promoting indigenous language as national languages, and ensuring their use in education and media. If I remember, if this still exists, I think there is indigenous media already exists in Taiwan, and that's, I saw one of my friends, my colleagues are the presenters on that TV. On top of that, we know that that Taiwan has also signed the many international human rights instruments, including ICCPR, including Convention on Economic Social Rights, also including the Convention on the Elimination of all form of discriminations. This is very important. Why? Because by the general comment of third committee saying that this convention applies on indigenous peoples. So, meaning that taking the land of indigenous peoples without free, prior consent can be accounted as racial discriminations, or the absence of law protecting indigenous peoples can be also counted as racial discrimination. And then I would also like to appreciate the latest adoptions of the Pingpu law. And I think we can discuss, elaborate more on that in these sessions to see how can we really make sure that the true recognitions can be done for the Pingpu, or we can call this the unrecognized, before unrecognized indigenous people. So this morning I want to touch on the several issues. First, we need to discuss the about the issues that we already discussed earlier, which is on the nuclear waste. And then the second one, I want to touch on how the follow-up on the free, prior, informed consent, because there is a plan to make it into codifications into the law. And then the third one is how's the plan to advance the recognitions of the Pingpu. We have heard some concerns from NGO, from indigenous organizations, that this is, some say this is unacceptable, undoable, impossible to do, because it puts so much conditions, yeah, on indigenous peoples to prove themselves to be recognized as indigenous first. And the second one is the categorizations. We have also touched in the previous that there shouldn't be a category on indigenous peoples. Indigenous peoples is indigenous peoples. There is no such mountain or sea or plain land, and then now we have the third category of indigenous peoples according to that law, to the Pingpu law, that doesn't attach to land rights and doesn't grant the rights for autonomy or self-ruling, internal ruling, as it is in the indigenous people's basic law. This, I think, we need to hear from the government, and I would like to give the floor to government.
Yeah.
I would like to start on the first specific questions. I think let's discuss the nuclear plant first, the nuclear waste first.
好，
Okay. On the solution or on the addressing of nuclear waste, I will ask MOEA and the Nuclear Safety Commission to respond to the questions. As for the Pingpu Status Act or Land Rights Protection of the Status, CIP will respond that. Now, MOEA, please respond to the nuclear waste question. MOEA want to properly deal with the waste and to promote the finalization of the depository of the waste. In 2004, MOEA Act was published in May. That is a radioactive waste dealing guideline, and we have an office for the implementation of that guideline. And the office was created in 2025, and the office work was to study the disposition solution for the high radioactive nuclear waste and the siting of the depository and the communication, as well as the geological survey. These are all part of the work of the office. And this office is very proactive in trying to promote the publishing of more legal framework. And we will have an open and transparent legislation process in picking the site for high radioactive depository sites. And we invite scholars and experts, as well as civil society organizations, to discuss how to choose the site for high radioactive waste. Nuclear Safety Commission also has the regulation for the final depository site for radioactive waste. And we already proposed 2 sites in Daren, in Taichung, and in Wuqiu, which is in Kinmen. We are working with Thai Power Company to engage local people. We hope to reach local consensus and to facilitate the local government to agree MOEA to hold referendum on those decisions. Thank you. This is Nuclear Safety Commission. You asked questions about indigenous peoples and nuclear power waste. I think you're asking about the Orchid Island and the current nuclear waste, which is located there. And our commission and NSC, abiding by the decision of the presidential office, we organize meetings every 6 months with TPC, the Thai Power Company, and MOEA, as well as CIP, the Council for the Indigenous. We also request TPC to provide quarterly reports to let us know the progress of changing the sites of the nuclear power waste from Orchid Island, and is submit to the Nuclear Free Project Task Force for following up. And we ask TPC to communicate with the society on its decision. And NSC also amend our regulation for selecting the sites, and it is added that if an indigenous land is picked, then it has to comply with the Indigenous People Basic Act, Article 31st. That is 31. That is about indigenous consultation. So indigenous consultation has to be given in order to have any developments on indigenous land. That is from NSC. Thank you.
接下来由
CIP speaking. In response to your questions regarding FPIC mechanism, according to Article 21 and Article 22 of our Indigenous Peoples Basic Law, if the government needs to use the Indigenous Peoples' land or wants to set up a national park on indigenous land, then consultation must take place and consent obtained. The same goes for wetland law and mineral industry act. So competent authorities have to comply with such provisions. However, as you pointed out, now only the administrative agencies are authorized to engage in consultations with the indigenous peoples. As for how private developers, provide proper information for the indigenous communities or apply adequate methods to inform the indigenous communities about their projects so as to prevent any deception, there is a lack or a shortage in this regard. So we are looking into possibilities to adjust the FPIC procedure. Hopefully, more detailed oversight will be set up. In addition, indigenous communities have made proposals about proper FPIC procedures. For example, it should be more diverse, more respect shown to the needs of indigenous peoples on the site. And we have released a draft on a draft, and now we are reviewing this draft internally. Secondly, regarding the Pingpu peoples, we have passed the Pingpu People's Identity Status Act, and you mentioned some concerns or misconceptions people have about this act. First, the conditions set for identification for Pingpu peoples are decided in accordance with the Constitutional Court's decisions. Basically, the people must have specific cultural characteristics, and there are historical objective records to refer to. So right now, for Siraya and other indigenous peoples, the government takes the initiative to investigate the conditions for identifying these indigenous peoples. Indigenous peoples do not have to provide or collect data and provide such data to the government for their identification. In addition, why we decided to have relatively lax conditions is because the legislators are aware that Pingpu peoples bore the brunt when the colonizers first arrived in Taiwan. Therefore, it's more difficult to identify their cultural characteristics. That's why there are relatively lax conditions required. So according to the Pingpu Indigenous Peoples Identity Act, basically the requirements are determined by members of the community. The same goes for the Siraya Indigenous Peoples Identity Act. As for the rights for indigenous peoples, according to the Grand Justice's judgments, for claims to rights, the government has to take into account the historical context of the indigenous peoples, i.e., in this case, Pingpu peoples. So now it is stipulated that within 3 years, the government has to set out laws and regulations regarding the rights of indigenous peoples. So the government currently is compiling the needs of different indigenous peoples so as to determine the laws and the regulations. And the Legislative Yuan is also making some resolutions or ancillary resolutions. And that's our plan for the next 3 years.
Yeah, thank you very much for the, yeah, because we actually still received the, why I'm asking about the Orchid Island's nuclear case, because we still received report, complaint on that, that says that the consultation is not properly done because it is done in a way that the real the people who were the most impacted by the dam site is not properly consulted. So I think this should be taken into account, and we need to hear on this more in the future. On the FPIC on the FPIC process, I think we need to, when you say internal draft, it is very. Can we get the more on the elaboration of the elements of this FPIC? Because what we in accordance to international human rights law, FPIC comprises of what we call free, prior, and informed consent. Free meaning should be free from intervention, should be free from intimidation, should be free from control from the outside. So it should be fully processed by indigenous peoples themselves through the language, through their timeline, through their own indigenous way of dealing things, indigenous way of making decisions. That's what free means. And prior meaning before. You cannot have free FPIC when you have already decided that you are going to use that land for a project. Or you cannot call it FPIC when you inform people only after you put out the license to the company. That is not FPIC. That doesn't comply with prior requirement of the FPIC. And informed meaning we tell. We don't just say adequate, but truth, comprehensive information. What will be the good impact and what will be the negative impact, the consequences that will be on everybody, on indigenous peoples, on the government, on the company. And consent, yes. After all this, they still have the rights to say yes or no. So I think we need to learn more about this, and drafting of this should I think I would like to see if this can be also open for indigenous peoples organizations to see. Otherwise, it's going to be the same problem again and again. There will be concerns arising, although after the FPIC law and regulations or codifications are taking place, and then you apply on the sites, we will still have concerns if from the beginning this law or this procedure is not allowing participations from indigenous people. So I want to see that plan in the future of developing this FPIC. And also the Identity Status Act, participation, full and effective participations of indigenous peoples is very critical, and it's very important, because who will define indigenous peoples is not the government. The government there is to protect, to recognize, and not to define. So I think this is very important to cooperate with the state indigenous peoples, the Pingpu, what's so-called the Pingpu, on who they really are. So it's according to the international human rights standard, it says right to self-identifications. So the indigenous peoples themselves, who will have to first say that we are indigenous, and then we come together, indigenous and government, to talk about things in between. What are the needs? What are the character? Why they call themselves indigenous? And it's also, I think, I want to hear the comments on the why the Pingpu only, how you call it, only the Pingpu laws, the Pingpu identity bill is only talking about the rights to culture, the rights to language, and it's not the rights to land and self-government, internal self-government. I think we need to hear more from that, maybe from the Council on Indigenous Peoples can give the elaboration on this.
Regarding the FPIC and its specific content, I will ask the CIP to provide more elaboration. As for the Pingpu people's identity and their rights regarding land and self-governance, also I would like to ask the CIP to provide explanation. Yes, CIP speaking. Regarding the Indigenous Peoples Basic Law and other laws, the FPIC is incorporated in them. For example, in the Basic Law, it says that government or private entities attempting to develop the public land adjacent to the traditional territories of the indigenous peoples or on their land for resources utilization, ecological conservation, or academic research, consultation and consent must have taken place with the indigenous communities. And accordingly, government in promoting any development or issuing permits for the use of land adjacent to indigenous peoples' territories, consultation must take place. For example, in the mining sector, any administrative decisions or dispositions cannot take place without consultation with the indigenous peoples. The administrative court has also made decisions that without consultation with the indigenous peoples, the government's permit is invalid or illegal, some permits have been revoked as a result. Again, the Pingpu indigenous peoples, I will use the Siraya people's case, for example. When we identify the Pingpu indigenous peoples, we do respect their right to determine who will be the members of their community. Take the Siraya people, for example. They themselves propose the characteristics and conditions and requirements. And then we announce these requirements and conditions to seek input. And finally, after the consultation, the Siraya people would have a look and have more internal discussions. And then they send another version of requirements and conditions to my council, and experts and scholars will have discussions with them again before we send this document for approval by the Executive Yuan. In the Pingpu Indigenous Peoples Identity Act, Articles 22 and 23 also touch upon this. We know that regarding language and cultural rights, more assistance and support are needed for indigenous peoples. That is why legislators in enacting this law points out that we must take urgent action to restore indigenous peoples' right to language and culture. As for other rights, of course, it may include the right to self-governance and rights to land and right to economic benefits. So they are all incorporated into the term other rights. And then it will take joint efforts between the Executive Yuan and the legislature to reinforce the other rights within the next 3 years.
And the legislatures also requires that the indigenous people's basic law should be the fundamental structure to lead to following legislations that can protect Pingpu people's rights in the future.
To make some comments.
I have only one question. I thought the last time there was an agreement that there would be a concrete timetable for the complete removal of nuclear waste from the lands of indigenous peoples, whether this was Orchid Islands or the Tao peoples in Lanyu. And now, if I understand correctly, we are still talking about referenda. But is there not only a timetable? Has nuclear waste been removed from the lands of indigenous peoples?
Regarding the removal timetable of the nuclear power plants, NSC or MOEA, anyone? NSC or MOEA? You are right. This is MOEA, and MOEA announced 2 candidate sites for nuclear waste in Taichung and in Kinmen. Currently, MOEA and TPC are proactively talking to the local communities. We hope to reach local consensus and facilitate local government to help MOEA organize a siting referendum. The specific timetable for the removal from Orchid Island will be decided after the final sites are picked. Before the removal, the storage sites on Orchid Island has good management and radioactive regulation to ensure the safety of the people on Orchid Island. TPC puts the low-level waste in the qualified storage and transmission dual container. And after the plan is done for shipping the nuclear plant, these containers can be loaded very quickly. NSC with MOEA and CIP also have the meetings every 6 months to discuss this matter. Thank you. Any additional remarks from NSC? We don't. Thank you.
So it means, of course, I do understand. In order to remove, you need to find a space where also the local communities would agree that it could be removed. But in terms of timetable, are there any kind of estimates from your side? How far is that process developed, and when would you expect that this nuclear waste might be removed?
MOEA, we're working hard to facilitate the referendum. So we are not able to clearly estimate when the removal can occur.
Okay. Yeah, I want to touch on another issues, and I think this is very much relevant, which is the latest review on the Convention of Elimination of all form of racial discrimination, which is like 2 years ago, right? As we all understand, the indigenous people's rights in all different conventions and international human rights standards, norms, and agreements have been in 2007 have been how do you call that in English, collected or integrated, yeah, codified in the UN Declaration on the Rights of Indigenous Peoples. So this has become, the UNRIP has become the guiding principles to guide parties, to guide government how to deal with indigenous peoples. And I want to again emphasized, maybe the National Human Rights Commission is not here, but I want to see if the government outside of the National Human Rights Commissions have concrete plan on integrations of indigenous peoples into the National Human Rights Action Plan, and also the National Human Rights and Business and Human Rights Action Plan. That's I want to hear from them.
Regarding whether indigenous rights be included in National Action Plan, CIP, and the Department of Human Rights from Executive Yuan will both respond to this question. CIP. Indigenous rights incorporated into NAP. CIP has always supported this direction. Now we are working with Executive Yuan's NAP and relevant laws. As long as it's possible, we want there to be a specific chapter or section for indigenous rights. Department of Human Rights, Executive Yuan. First of all, we discussed a draft of the second NAP, which will be published at the end of this year. In the second NAP, there are indigenous people's human rights, so they are part of the current structure. Second, you asked about the concluding observations and recommendations of ICER 2 years ago about how to incorporate indigenous rights, how to consider the UNDROP, or whether or not there should be a more unified indigenous people's human rights plan. Well, in fact, in March, we confirmed the government responses and its actions to ICER's CORs. There are actions being planned for indigenous peoples. We hope by next year we will have a thematic NAP for indigenous peoples. This is the current plan of the government.
I have still only one other question in relation to Article 1. And in the in the fourth report, page 1, you say under the self-determination that there are also direct possibilities of the people participating through referenda and a direct popular vote. And I have two questions. The one is that the voting age for direct popular vote is 18, whereas for elections it's 20. Can you explain this difference? And the second question is, does every constitutional amendment after having been adopted by the legislative yuan has to be put to a referendum? And the third question, in the last years, how many popular referendums or referenda have taken place? Thank you.
How?
Regarding the age for voting, 18 or 20, that's the first question. As for the constitutional amendment procedure, whether referenda has to be part of it. And the third question is about the number of referenda we have held in recent years. Central Election Commission, please. Central Election Commission speaking. First, the age for popular vote and referenda, according to our Constitution, for people aged 20 and above are eligible voters. So basically, people who are aged and older can vote. As for the eligibility to take part in referenda, the Constitution doesn't provide for that part. So we have a Referenda Act which stipulates that those who aged 18 and above can take part in a referendum. The second question is whether the constitutional amendment proposed by the legislature, whether or not it has to be reviewed and approved by referenda. According to the constitutional amendment proposed by the legislature, for example, any changes to the territory, yes, they have to be reviewed by the referenda. Also, speaking on behalf of the Central Election Commission, since 2003, when the Referenda Act was released, we have held 21 referenda, one in relation to a constitutional amendment. So in 2004 once, 2008 once, and then in 2018 once, and 2021 once, and in 2021, that's when the referenda on constitutional amendment was held in 2025.
Thank you very much. Still on the last question. So you said 21 referenda were held. One was on a constitutional amendment. That means 20 on other issues. But who is deciding whether legislative amendment is subjected to a popular referendum? Is it a certain percentage of the people who can request it, or is it the legislative yuan? So what are the kind of constitutional preconditions that a certain act or a certain question is put to a referendum by the people?
regarding the referendum procedure, again, Central Election Commission, please. Yes. Regarding the procedure, according to the Referendum Act, there are several types. First, in accordance with the Constitution, the others include those initiated by the people, by the legislature, or by the president. Referenda initiated by the people basically take this year, for example, 1,955 people must have proposed, and 3,228 people must sign on the petition in support of this proposal. As for those initiated by the legislature, according to the addition to the Constitution, basically the legislature must announce the proposal for referendum for 6 months before the referenda takes place. And according to Article 12 of the Constitution, any constitutional amendment must be proposed by 1/4 of the legislators, and that means 3/4 of the legislators must be present, and decisions made by 3/4 of the attending legislators. After the 6 months, then eligible voters can take part in the referenda. So for any constitutional amendment proposals, the 1/4 of the legislators propose, 3/4 present, and 3/4 of the present legislators agree to make this proposal.
Is held, it is legally binding. Is that correct?
Central Election Commission speaking. The referenda result, whether it is initiated by the legislature to amend the Constitution or any other referenda, the result can be legally binding. According to the Referendum Act, according to Article 30, after a referendum, then the Election Commission will have to announce the result within 7 days. First of all, for initiatives on legislative principles for laws or self-governance ordinances, the executive yuan, municipal government, or county government shall within 3 months draft a bill for the relevant law or ordinance and submit it to the legislative yuan. For referendums on major policies, the president or the competent authority shall take the action necessary to implement the content of the referendum. For referendums held under the Constitution, the legislative yuan shall consult the president to promulgate. So they are all legally binding.
Sorry to. So even if the initiative for a referendum comes from the people and you have a certain amount of citizens who support the referendum, then the referendum must be held and it is legally binding. Without involving the legislative yuan, I'm not totally clear, or does it have to go then through the legislative yuan?
Central Election Commission, according to our current act, there are 3 ways to initiate a referendum. First, by the legislature in accordance with the Constitution, or a referendum can be initiated by the president, or the referendum may be initiated by the people. The 4th one is the public referendum proposed by the legislature. So there are 4 types. For the 3rd one, initiated by the people, the legislature doesn't have to be involved. It doesn't have to be approved by the legislature because it is initiated by the people. So the 4 types of referendum, basically, the vote count has to be conducted in accordance with the Referendum Act and the amendment or the addition to the Constitution to decide whether the proposal has been approved or disapproved, and the result is legally binding.
I think if there are no more questions on Article 1, and I guess also on Article 27, then we move to the 3 provisions dealing with equality and non-discrimination. These are Articles 2, 3, and 26. And I give again the floor to Ruka.
Yeah, thank you very much. On this, I think I will just follow up on the previous review on how is the follow up on the disaggregated data, because we have that recommendation in the past that we need to have the disaggregated data on indigenous peoples. Based on that, then we can have targeted programs on the empowering of indigenous peoples. I think that's the first questions on the disaggregated data. And the second one on the addressing the historical injustice. I think earlier we discussed, you mentioned about the realization that the Pingpu were the one who were firstly colonized. And therefore, with that realization, there must be addressing the historical injustice to them. Can be in form of rehabilitations or can be in form of like rehabilitation and restitutions. I think this can be. I want to hear if there's any thoughts from the government on this. So that's first. Thank you.
Regarding disaggregated data, maybe the Director General for Budget, Statistics, DGBAS, can provide explanation. As for the rehabilitation and restitution for indigenous peoples, CIP, please. Do we have representatives from the DGBAS, the Government Statistics Office? Well, my apologies. We do not have representatives from the Government Statistics Office. Regarding the CIP, I think the CIP can provide data collection and disaggregation.
CIP. You ask about disaggregated data for indigenous peoples. CIP, with the support of Executive Yuan, already has a plan to manage the indigenous wisdom or intellectual properties or information that is, indigenous governance plan is the name of the plan. That means we want to integrate indigenous data, including students' data, parents' data, economic data, industrial, family, household income. We try to compile all of the information. And this plan has to go through many other different agencies and ministries because there is so much different, so much information. So we do have an indigenous governance plan going on about data collection. Second, about historical injustice for indigenous peoples. What is the status, or are there any activities? There are two things I want to raise. CIP had raised a draft of historical justice and rights restoration, but when this bill was discussed in the Legislative Yuan, there were so many different opinions. So that legislation is still ongoing because more discussions are needed. As for Pingpu peoples, before the status law was enacted, CIP already designed a plan to revitalize indigenous people's language and culture, and there was funding for that. So there were plans for Pingpu peoples. They can create their gathering centers, build their communities, engage in traditional rituals, and continue to protect their culture and language. With the National Language Development Act, we also have some responsibility to help the revitalization of Pingpu people's language, which is still ongoing. Thank you.
Yeah, thank you very much. The draft of the historical injustice, it sounds in the legislative yuan sounds promising, but again, it has to be in full and effective cooperation with the indigenous peoples, representatives and organizations. Thank you very much for that. In terms of funding, funding needs to be long-term, and it's not just on not just on projects like building, cultural centers or cultural service centers, but it's more on the long-term plan, and needs to be also again in cooperation with indigenous peoples and other relevant actors. I would like to hear on the, since we're talking about discriminations, I think first I want to bring us to the other side of the conversation, which is also part of the human rights, is about the climate change and environment and biodiversity. The recent case studies by international intergovernmental panel on climate change, and also by the same panel, IPBES, for biodiversity, saying that the key ecosystems that remaining today in the world because of indigenous peoples. So indigenous peoples are our guardians. They they guard, they secure, they take care of the best ecosystem we have today in the mountains, in the forest, in the river, in the lake, in savanna, and in the water bodies like river, seas, and oceans. Therefore, it is also very important to include them in the mitigations strategy for climate change and also in environment. But yet today, we also heard the concerns from indigenous peoples organizations that they continue to face discriminations in terms of their traditional livelihood, like hunting and fishing. Is there any, while hunting and fishing is also protected by international law, which is ILO 111, the rights to education. So I want to bring this another element that we didn't actually discuss in the previous review on the relationship between indigenous. Why investing in indigenous peoples is very important, because it's the guardian of our Mother Earth. So we still survive today because of indigenous peoples are taking care of the places where we get our oxygen, where we get our water, our air. So I think I want to hear if there's any thoughts and plan from the government on this, and specific questions on the concerns about criminalizations and discriminations of livelihood, traditional livelihood of indigenous peoples, including fishing and hunting. Thank you.
好，这个问题
Okay. These questions are within a large scope about climate change and national land management. Maybe Ministry of Environment, Ministry of Interior, and CIP can respond. Ministry of Environment is not present, okay? So maybe Ministry of Interior. And indigenous questions and their role in climate change, then we ask CIP to respond. CIP, as for traditional livelihood of indigenous people and the protection of it, first of all, based on JY interpretation A03, indigenous peoples can live their life in the traditional manner, and that way of life is protected by the Constitution. After JY interpretation A03 was published, CIP also adjust our regulations with the Ministry of Agricultural Affairs and Ministry of Interior, including the Wild Animal Conservation Act, so that indigenous peoples are able to hunt wild animals, so that their traditional way of life doesn't have to be limited. Other than that, the Guns, Ammunition, and Knife Act has also been amended that allows the indigenous peoples to use best or better quality hunting guns, again, for their traditional life. So after interpretation AO3, these legislations have been amended. Thank you.
Yeah. Thank you very much. The issues of gender equality and also a participations of indigenous youth and women in development, in participations in consultations, in public hearings, in votings, in decision makings. Is there any progress on that?
好，这部分是不是先请性平处，行政院性平处。
Department of Gender Equality of Executive Yuan. Can you give a general or comprehensive answer? Department of Gender Equality. You asked about indigenous women. Maybe representing in some governance mechanisms. The Executive Yuan has published a gender policy guideline, and in 2021 it was amended to enhance protection for indigenous peoples. In 2025, the gender equality core issues were published. From 2026 to 2029, we have several issues that last in the span of 4 years, including facilitating equal gender participation in companies, including indigenous participation and their rights at different levels. There are promotion strategies. We ask all the ministries, including CIP, to have their own gender equality promotion plan, and we will have an assessment system to supervise them. CIP, for example, has their gender equality task force. In this task force, there are people from CIP, people from the general public. Okay. Gender equality or women's rights, CIP, you may want to respond. Yes, this is CIP. As Executive Yuan said, in Executive Yuan's gender equality policy guideline and specific promotion policies, CIP has our own gender equality implementation plan and a task force. Currently, for indigenous traditional organizations and the functioning of community operation, we are collecting gender statistics because we have noticed that indigenous representatives have noticed that scholars have reminded us that participation shouldn't be different on the grounds of gender status or family. So we are working with local government to survey whether there are gender gaps in indigenous participating traditional organizations and decision-making in community meetings. If there are, we are discussing how we can support such communities to improve gender equality while still protecting the subjectivity and the cultural right of indigenous peoples.
Thank you. In the list of issues which we prepared, a question was asked about provisions of legislation that appeared to be discriminatory and to have comments on when they would be repealed. Let me refer you to page 102 of the replies to the list of issues. Paragraph 3, which refers to Article 288 of the Criminal Code, which deals with punishment for the crime of procuring an abortion, or I believe assisting in the procuring of an abortion. And it discusses in that paragraph the question of whether abortion should be decriminalized and raises this issue
about achieving a social consensus on the matter. And then it concludes saying that following collection of diverse opinions, the public notice for the draft amendment to the crime of abortion was withdrawn. I think perhaps an uninformed reader such as myself would have the impression that what was being proposed was legislation to decriminalize abortion, and that legislation had been withheld, or that proposal failing consensus. But my understanding now is that it was actually the opposite, and that what was contemplated was harsher penalties under the abortion provision of the criminal code. This is an issue that arises under Article 3 of the Covenant, but also, of course, in relation to Article 6 on the right to life. And you may be aware that in General Comment 36 of the Human Rights Committee on the right to life, they discuss the issue. There's a paragraph dealing with the issue of abortion. And the paragraph recognizes that states have a right to regulate abortion in their legislation. It's not very prescriptive on what that should involve, but it leans heavily towards the decriminalization of legislation dealing with abortion, and above all, and this is where the issue of gender equality arises, that the legislation becomes ultimately something that is can be discriminatory against women. It strikes me that there is this problem with the legislation currently in force with Article 288 of the Criminal Code. But also, it's rather troubling that since the last review, and in the past 2 years, there have actually been proposals to make the punishment harsher than it was previously. So I'd be very interested to hear comments on that, on the situation with regard to the criminalization of abortion in Taiwan. Thank you.
Regarding Article 288 of the Criminal Code, the MOJ, please. The MOJ, the Prosecutors Affairs Department speaking. On the issue of abortion, whether it is criminalized, according to the Genetic Health Act, there are 6 grounds on which abortion is legal. The first one is the voluntary abortion, that is the woman and her spouse have genetic or contagious disease or mental disorder, or the pregnant woman and the spouse's relatives within 4 degrees of kinship have genetic disorders, or by medical consideration, risk of teratogenesis that may present for the fetus, or pregnancy as a result of being raped, lured into sex intercourse, or into sex intercourse with a man prohibited to lawfully marry her, or pregnancy or children likely to affect her mental health or family life. Especially the 6th type, that is family life, mental health of the woman may be affected. That can be a legal ground for abortion. In addition, according to the implementation rules for the Genetic Health Act, abortion must be carried out within 24 weeks of the gestation. However, for medical behavior, this restriction does not apply. So for abortion, basically you have to consider the grounds and the gestational period. I believe these provisions have taken into account the pregnant woman's right to her health, autonomy, and reproductive autonomy, as well as protection of the fetus. So the provisions in the Genetic Health Act will not prevent or prohibit abortion completely. So women will not be criminalized in accordance with Article 288 of the Criminal Code. If we remove Article 288 of the Criminal Code, then pregnant women will be able to engage in abortion at will without any criminal responsibility. Whether or not this is in line with our people's value judgment and the balance between fetus right to life and women's right to her autonomy, that's something more social consensus needs to be forged before a conclusion can be drawn. So we withdrew the amendment to the abortion criminalization. Basically, it's because we would like to discuss further the monetary fine for abortion.
Explanation. What is unclear to me is why you were proposing to increase the penalties. This suggests that you think there is a problem with the application of the legislation and that the abortion is not sufficiently prevented, as you say, by the existing legal framework, and that somewhere there was an assessment, I guess within the Ministry of Justice, that harsher penalties were required in order to prevent women having abortions that were not consistent with the law. Is that correct?
MOJ speaking. Previously, the monetary fines were determined based on our old economic conditions. So we decided to take a review of the overall monetary fines in the whole criminal code. That is why the monetary fines for abortion was also affected. So we did not target monetary fines for abortions. Therefore, there's no harsher penalties for abortion criminality because we have withdrawn that amendment.
Statistics about the number of prosecutions there have been under Article 288 in recent years, and whether they lead to convictions or acquittals? Do you know how can you tell us about the application of that provision in the criminal justice system?
I think I can answer this question on behalf of the MOJ. In fact, the draft amendment was proposed in relation to higher monetary fines. Why? It's because the monetary fine amounts were determined decades ago. So our economy has advanced a lot. Therefore, we thought it would be time for us to reconsider the monetary fines in the criminal code. That's why the monetary fines have proportionately increased. The proposal or the amendment we made then didn't target abortion. Rather, it's about the criminal code overall to reflect our economic conditions today. So that's some additional information I would like to provide. As for the prosecution, conviction, and acquittals of the Article 288, again, the prosecutor's office, please. Yes, thank you for your question. As far as I know, in the past 10 years, prosecutions on abortions, 0. There are only prosecutions targeting physicians who try to profit from providing medical abortion procedures. But this this patient may be a minor without parental consent, or adult women going through abortion without providing consent from their spouses. That would constitute a violation of the Genetic Health Act. So there are a couple of prosecutions in the last 10 years because of this. No women were penalized because of abortion in the last 10 years.
Permit me, I want to just tell you a little personal story about this issue. I've lived a major part of my life in Canada, where since a decision of the Supreme Court under the Constitution in 1987 declared criminal law provisions dealing with abortion to be unconstitutional, there has been no legislation in Canada since 1987 governing abortion. It's completely unregulated by the criminal law. And there's no sense, to my knowledge, in Canada that there's a feeling that this is a subject of abuse. I left Canada in the year 2000 and moved to Ireland, where at the time there was not only a criminalization of abortion, there was a constitutional prohibition of it. So the exact opposite of the situation in Canada. And it appears from the studies that have been done that women in Ireland at the time were getting abortions at about the same rate as women in Canada. In other words, whether you have a total prohibition or you have a legislative vacuum, women are going to do what they decide they have to do. And the legislation, so my sense is that, and I'm in a way comforted by you telling me that there have only been a few prosecutions. I think that's probably unfortunate because it will have a chilling effect on competent physicians who are trying to assist women in obtaining the abortions that they need. And so it's very difficult to know how discouraging that is for physicians. I suspect that they may be more concerned about disciplinary measures taken in their professional bodies, but this I have no knowledge about. But I wanted to share that observation with you. Thank you.
On this, I would like to add again from the OJ's perspective about the right to women's own body and protecting the right to life of the infants. I think another MOJ representative has said that there should be a balancing of these two rights, and in our country still, Criminal Code 288 is still there. But since we also have a Genetic Health Act, which was also mentioned, there are grounds that are provided in order to protect women's life, or because of special conditions. For example, women become pregnant not of their own will, or their safety is in danger, and then Genetic Health Act can be invoked. And these two pieces of legislations are in place to balance the right to people's own bodies and the right to life of the infants. And as another representative said, even though there is such an offense in our criminal code, but I don't think in the past 10 years there were any cases in which women were given a guilty verdict because of abortion. So I think abortions should that occur are in line with the grounds in Genetic Health Act. The only possible offense related to abortion is because there are illegal circumstances or doctors provide abortions in order to gain monetary benefit. And so for other abortion cases, and at least in the 10 years, I don't think there were any women who were punished under this provision.
Thank you very much. I have a totally different issue that I would like to raise. And that is that in the covenant under Article 4, you have the possibility in time of public emergency that the states parties may take measures derogating from their obligations under the present covenant with certain exceptions. Now, in your fourth report, there's only one paragraph, 35, which says, since the incorporation of the two covenants into domestic legislation in 2009, Taiwan has never announced or rescinded its obligations for protecting the rights specified in the covenant in accordance with the regulations of this article. And I'm, of course, very conscious about that, in particular in a country where you had martial law for quite some time. My question is more, therefore, for the future. I mean, taking into account the fairly difficult political situation that you face currently, and we discussed it yesterday, that there is a kind of a situation where some of the major constitutional bodies are no longer fully functioning, like the Constitutional Court, and that might also soon apply to the Control Yuan and the National Human Rights Commission. And there are threats also from outside. What are the legal provisions that in such situations, when Taiwan feels that you are entering a situation of public emergency which threatens the life of the nation, what kind of derogation measures would the Constitution and the respective laws actually allow in terms of, and we heard already about certain polarizations, hate speech, terrorists, threats, etc. And are there certain plans within the executive yuan how you would respond to these types of threats?
This is a very broad question. Exemptions and derogations during state of emergency, and I will ask Department of Legal System of MOJ to respond. Even though currently we do not announce any derogation of the obligation, but in terms of Constitution, Article 23, on grounds of interfering other people's freedom or in emergency in order to maintain social security or in order to facilitate public goods, those things, well, in order to facilitate those goals, sometimes freedoms may be properly limited. After martial law was lifted in 1987 for Taiwan and in 1992 for the Kinmen and Mazuot area, there have never been any major limitations on fundamental rights. That's our response for now. Thank you.
Well, I'm just asking Professor Novak about the legislation implementing the International Covenant on Civil and Political Rights in the laws of Taiwan, because Article 4, in a way, is an article directed at treaty implementation, and that's why it provides for notification to the other parties to the treaty. It's kind of the purpose, I think, of Article 4 when the derogation takes place. And so I'm just curious as to how, or maybe why, you would have such a provision. Let me put it another way. When you're incorporating the covenant in domestic law, why you would need to have a provision on Article 4, because you can derogate anyway, and you don't need to notify anybody because it's public legislation in any case. It becomes apparent to your public. But this is just the musing of a university professor, I think. Maybe it's of no practical consequence.
No, but I still think that every state has certain constitutional or other provisions which regulates that in case there is a public emergency, that might be an earthquake, that might be a tsunami, that might not only be a war, there are many reasons why there might be a public emergency, and then you need to have legal provisions which enable the president or whoever else would have this power to impose certain measures. And certain measures might restrict or derogate from certain human rights obligations. On the question of notification, I would think that the International Review Committee would be the appropriate body to be notified. No, yeah, I mean, it's our task to review whether the measures taken by the government of Taiwan are in compliance with, in this case, Article 4, which says you only may take measures that are not inconsistent with the other obligations under international law, that do not involve discrimination. There are paragraph 2, which says that no derogation from Article 6, 7, 8, etc. may be made under this provision, etc. So I would think that this is part of our task to then review whether or not emergency measures are actually complying still with Article 4, apart from the notification to the other states parties. So that's why I was putting the question. I fully respect if you don't want to respond to it, but there must be legislation in Taiwan for such an event. And as I said, you are currently in a situation that's some kind of, I mean, if all the major constitutional bodies are no longer functioning because the legislative yuan is not appointing the members, I would call this an emergency. And how would you respond then? So would you like to respond? Of course, you don't have to. It's just a question of us.
好，因为委员一直提到我。
Okay, I think the committee members are concerned about constitutional court not being functioning, and whether that is an emergency. Maybe Judicial Yuan, you can respond to the question on constitutional court and its current functioning. This is Constitutional Court Secretariat. So the legal quota is 15 grand justice, and the current judges on our 8, it doesn't reach the legal quorum. But after the constitutional judgment number 1 in 2025, the Constitutional Court has been able to make judgments. This year, there are 4 judgments. So Constitutional Court is still functioning. It continues to serve as a constitutional body.
No, we have discussed it yesterday and we know that. The question is that there are also constitutional judges whose term comes to an end in 2026. And if again the same situation will apply, that no judges can be appointed, if you only have 4 judges left, I think there's a certain point that you reach where the court cannot anymore properly function. But my question was going far beyond that. It's not only the Constitutional Court. The current impasse between the executive, the government on the one hand, and the legislative yuan might lead into further measures that make the current constitutional bodies dysfunctional. And are there any plans by the government that you would invoke Article 4 and say that is an emergency where we have to take special measures? So that's not so totally out of the blue, but perhaps David would like to add something, please.
Thank you. I don't want to weigh in directly on this point, but it's related because Professor Novak highlighted sort of an instance or set of instances in which emergency might be relevant, and that is national security or public order and so forth. And I just wanted to, in a sense, highlight the relevance of this conversation to the conversation that I think we'll have tomorrow about the Social Order Maintenance Act. And to the extent that we can have a rich discussion tomorrow about the dividing line between the application of that act and the need for the government to declare a derogation from the covenant, I think that might be a useful place to have this conversation in a very concrete way. So I'm not asking for a particular answer right now, but to the extent we can have this conversation tomorrow in some depth and detail, I think it might be useful for us to understand how you see national security, public order, possibility of either implementing the law versus requiring to derogate from it. Thank you. So, do you want us to respond to your comments?
If you are able and willing to respond, of course.
关于这个涉及
I think this inquiry has to do with the disagreement between the executive yuan and the legislative yuan. We do have constitutional institutions in place, but does that constitute a state of emergency in Article 4? I don't think we have ever applied Article 4 to have any derogations of rights. As for, in practice, how we can break the gridlock between the two branches of the government, we are a democracy. So we have democratic and legal as well as constitutional frameworks to help us. In reality, the executive yuan will continue to engage and communicate with the legislature. As for the higher level constitutional issues, we may not be in the position to answer it.
Can we come back for a minute to the Constitutional Court issue? Because as I understand it, there is a requirement that there be, well, 15 judges is the normal composition, and that you need 10 judges for it to function, but that it is functioning with fewer judges. Do I understand this correctly?
No, because the Constitutional Court has decided that this amendment was unconstitutional. So they gave themselves the power to in a smaller formation, but there are now currently 8 judges. 5 judges are in favor, 3 were dissenting. So they had a small majority, so they could hand down 4 judgments. But of those 8 judges, if I'm correct, 4 will actually have to retire this year. So then they will be reduced to 4 judges. I have no idea whether these 4 judges will then continue to issue constitutional court decisions.
That's my question.
And the question is then to the government, if you cannot solve this kind of dilemma or this conflict between the executive and the legislative yuan, do you have any kind of plans, and including plans that might involve an emergency? But I understood that there was no willingness to actually go into this into this discussion. But of course, it also directly touches on the SOMA and also the national security law, and there are already fairly far-reaching restrictions on freedom of expression and freedom of assembly, which might be within the normal limitation clauses of Article 19 and Article 21 of the Covenant, but there might perhaps also need certain derogations, I don't know. But that is something we will discuss tomorrow when we come to Article 19. On the Constitution...
My question, Manfred, is simply, if the Constitutional Court can function with 8 judges, and possibly with 4 judges, could it function with only 1 judge?
The Judicial Yuan, please help us answer this difficult question. The Constitutional Court speaking. As you mentioned, Article 30 of the Constitutional Court Procedure Act, 2/3 of the current quota must be present for deliberation, and half of the total quota can make a judgment or decision. So in that case, is it possible for or even 1 judge can make a decision? It's possible, but it really depends on how the great justices interpret the separation of powers stipulated in the Constitution, and how the great justices can exercise their duties. The great justices have to adhere or follow the Constitution because they are supposed to interpret the Constitution. So for laws that contravenes the Constitution, the great justices will still make decisions in accordance with the Constitution and the Constitutional Court Procedure Act. So if the great justices believe there's no concern of unconstitutionality, then the current threshold still applies and they can make decisions. But at the end of the day, great justices will have to make interpretations of the Constitution based on the Constitution. That's all from us for now.
But we can ask again. May I also take this opportunity to come up with a proposal from Chauffeur O'Leary yesterday, that since we were told that the chances of having a meeting with representative of the legislative yuan are more or less 0, could we then have the legislative materials, when the deliberations were that led to the 96% of budget reduction in the legislative yuan? could you provide that in an English translation to us? That would be great. So we would like to understand what the reasons behind were, and perhaps also what the different opinions in the legislative yuan were on these issues. And the other question was whether we could still, because I also don't have with me now an English version of the Constitution of Taiwan. If you have some copies that we could have to look into this very exceptional kind of situations that you are in.
Regarding the budget cut, maybe the control yuan can provide additional information. Well, I believe the control yuan must have taken part in the process when the budget was cut. So the English translation of our constitution, I think the judicial yuan or the MOJ would have, we will provide you the copies of the English translation of our constitution this afternoon. And maybe the control yuan can provide some information or explanation about the legislative process that resulted in the budget cut for the NHRC. Yes, the control yuan speaking. I think we can compile relevant legislative material and provide you these materials later. We will provide you later after this session.
So, if I'm correct, there are no further questions from our side in relation to Articles 2, also 1, 2, 3, 4, but also then 26 and 27. So there are two possibilities. Either can we continue with Article 6, 7, etc., which is foreseen for this afternoon, or would you prefer that we actually terminate this meeting now and have a longer break?
Well, I think for Articles 6 and 7, different government agencies are involved, so they are not present here yet. Maybe we can follow the original schedule, and we discuss Articles 6 and 7 in the afternoon.
So then that brings to an end the current session. Thank you very much for all the answers. And we will have the next session with non-governmental organizations at 11:30, yes. No. At 11:30, yeah. Okay, thank you.
Meeting with non-governmental organizations, session 2. Please pay attention to your speaking speed. For interpretation, please also raise your hand before you speak. Identify your affiliation. After you are done, please switch off microphone.
Hello. Yeah, good morning again. We had this morning a fairly short meeting, which was primarily on the rights of indigenous peoples in accordance with Article 1 and 27 of the Covenant on Civil and Political Rights, and then a few questions relating to the right to equality and non-discrimination under Articles 2, 3, and 26. And we also entered into some discussions on the possibility of emergency measures under Article 4 of the Covenant in case of threats and emergencies, including the possible dysfunction of the Constitutional Court, or perhaps also the Control Yuan and the National Human Rights Commission. So I would like again perhaps ask Ruka first to put questions to you in relation to indigenous people's rights, and then of course we enter into a general discussion on these topics. Please.
Ya, Kure Sumanga, thank you very much. Terima kasih. Sisters, brothers from civil society, today we discuss, this morning we discussed about the follow-up questions, and based on the response from the government provided to the review committee in the written document. If you can see that in the last review, we have highlighted several issues concerning indigenous peoples. We got some response updates from the government, but we also still receive issues, concerns from civil society organizations, especially from indigenous peoples organizations. This morning, we heard that there is already improvement in terms of the handling the case of the nuclear waste. So I think if any one of you get information on that, please update us. I'm just listing now the list of topics that we need to hear. First on the nuclear, and then the second one of how the free, prior, informed consent have been applied, because they repeatedly saying that it's been in place and we have consultations and we have consultations and consultation. That's what we heard. That there's internal review now for the draft on the FPIC. Have you heard about this? And are you part of these discussions? And then the third one on issues is on the Pingpu. According to the government, all the research now is actually in cooperation with the Pingpu, the state Pingpu, especially in the case of Siraya, that they mentioned earlier, that actually it's all information are provided by the members of the community, and also, so the government is just compiling, and everything is by the input from community, and in the end approved by Executive Yuan. On the language, we also heard that the National Human Rights Action Plan is going to have specific chapter on indigenous peoples. And yeah, I think that's for a situation today. We didn't ask much about the data disaggregations and also the gender-based data disaggregations, because I think that is being tackled by the other review team under the economic, social, and cultural rights. So please, if anyone can already provide us with some information. And sorry, I forgot to mention about the criminalizations of indigenous peoples' rituals, fishing, traditional hunting, by the law of wildlife conservation and also the gun control. If anyone can provide us feedback in updates on these situations. Thank you very much.
Thank you. The floor is open. Yes, please.
请说。这边第一位，这边第二位。Thank you. I'm a lawyer from Environmental Rights Foundation. I want to discuss FPIC consultation. The consultation approval guidelines, in fact, are decided to be illegal or unconstitutional, actually, by courts, because many of the articles there are contradicting with cultural rights. Because if communities do not want to convene meetings, they think they want to reach consensus internally first. The local agency can force the indigenous communities to convene meetings. And then the community discussions approach is, or how it is done, is decided by the government, because the government decided that it has to be done by household registration. But many communities do not discuss based on households, because there are the elderly, there are the families or the tribal families. These are different concepts from a household. But it seems that the communities are forced into making decisions in some way. And who are the community members? Some are indigenous peoples, but they are from other community. But per the current Constitution Act, they can vote. The court has announced that some of these provisions are illegal and unconstitutional. It has been 3.5 years, and the government and the CIP has not amended the laws yet. And after the court judgment, indigenous communities have built their own provisions. We refer to provisions in the state of Australia to form our status regulations or land regulations using traditional approach in order to exercise community-based rights. However, after communities made their decisions, the CIP said that you cannot do this as communities. We do not acknowledge your decisions. CIP even notified some vendors, because the communities have already reached agreements with some vendors for geothermal power, and the CIP said to the vendor that we do not acknowledge this decision. You cannot do this. The vendors are worried that the development project would be successful. Therefore, the vendors reject fulfill the contract. What CIP does is that they do not amend the illegal laws, the unconstitutional laws. Instead, they interfere the communities. I think these activities violate our rights into covenant. This is Taiwan Indigenous Youth Public Participation Association to respond to the to the earlier speaker on FPIC. When FPIC consultations were done, the government says that we respect community opinions. But these opinions then will have to go to local agencies for them to approve that, okay, these decisions are agreeable, and then the government would approve. So as mentioned earlier, sometimes local agencies do not agree that such decisions can be done using the indigenous community's own way. Then who are the members of the community who can join the consultations? There aren't clear definitions or regulations. For example, this person is from this indigenous community, but this person travels a lot. He or she does not live here, but based on the Consultation Act, they can still participate in the meeting. Some people do not have biological relations with the indigenous communities here, but the indigenous peoples recognize him or her as a member and therefore think they should join the consultations. Now, many young people leave the indigenous communities to urban areas to study or to work. And in Taiwan, the household registration may change when a person go to a different place to study or to work. And when somebody's household registration is not in the indigenous community, they're not able to vote under FPIC Consultation Act. And these are some of the conditions when the indigenous members are not able to truly express their opinions. Another issue with the FPIC. So prior and informed are important elements, but when CIP was designing the procedure, they were not making sure that the information could be understood by the indigenous peoples, because in the communities, there are elderly indigenous peoples or people with lower education. But the language used, though it's in Mandarin, sometimes I don't even understand. We don't even understand. When the government think that they have already told us about what's going to happen, and they provide information, and they think that's done. They think that is equal to provision of submission. So they read the regulation, they read through the text, they read through the project, and they want us to vote. Everything happens in a rush. Nobody knew why we were there. And however, CIP thought that, okay, so these voting results meet the requirements under FPIC. Second, if the results achieved by the communities are different from what the government expect, they will convene one meeting, two meetings, a lot of meetings, and we don't understand what the meetings are going to be about. They keep saying that, oh, we will provide detailed information. We will provide detailed information. A recent example is a development project in Taitung in eastern Taiwan. In 1 or 2 years, and they convened 11 meetings. The goal is to vote. It's time-consuming. These are all administrative procedures. It seems that they're trying to show that they respect indigenous opinions, but in fact, that respect is not realized. So that's my remark about FPIC. About Pingpu peoples and the identity status, I think this morning CIP and the government said that they respect indigenous opinions. They initiate some surveys. Well, about this, the so-called active surveys, if done properly, should be like this. Indigenous people says that, okay, we want identification of our status, and the government provided resources. But in realities, some peoples ask for such identification. It's been 3 years. There's no update at all. Why can't such identification be done? No one knows. It's been delayed. It's stuck. There is a procedure, but it is not applied well. And the CIP mentions Siraya people. They have the larger population among all the Pingpu peoples. They have more complete procedures. Siraya people has a challenge here because the identification timeline can go back to really early in time. So to identify people to be Siraya people, there could be some difficulties. For example, CIP asks for household registration from Japanese colonial time. If you were registered back then now you can be recognized as an indigenous person. But those informations back then were from a long time ago. A lot of information was lost, and at that time there was a patriarchy and many other social issues. Indigenous people didn't want other people to know that they were indigenous people, so they were not necessarily registered. So how to prove a person is an indigenous person? So some show their genealogy from their family, so they have a family book saying this is our lineage in our family, but CIP does not recognize that. CIP only require, or the CIP require that the official registration data be provided. And in the procedures, they may say, oh, if you need more ways for identifying your status, we can discuss. We don't know how much longer we're going to discuss. Some indigenous peoples will change their mind because they don't want to delay. They don't want to wait for another 5 or 10 years. So they will accept the proposal of the government. That's what the government call people's consensus.
In addition, on rituals, traditional customs, fishing, hunting practices of indigenous peoples. A few years ago, there's an incident in Taiwan. An indigenous hunter was sentenced because of hunting. But then in 2024, he was acquitted. And then since then, there were amendments to the Control Act of guns, knives, and ammunitions. However, they did not take into account indigenous traditions and knowledge about guns, knives. Therefore, the government continues to put more restrictions on the use of guns and knives. Consequently, when indigenous hunters use the hunting guns and knives, they are unable to leverage their indigenous traditional wisdom or knowledge anymore.
We have interpretation, so please try to speak not too quickly so that it's not too difficult for our interpreters to translate. Uka, to you.
Yeah. When you say earlier it's not accepted by local agencies. Yeah, these government agencies or CIP agencies or indigenous institutions.
Well, the result was not recognized by the local public institutions like city or county government. This is because there were certain rules. There are provisions saying that our council decisions must be recognized by local government because the CIP is at the central government level. So the CIP says the local government must recognize the legality of the council decisions.
Okay, I think I have enough information on that. If there's anyone others information that we need to hear about the progress of indigenous peoples so far, we're not going to take on the data disaggregation because it's being taken in the other side, in the other room. So if there's any more concerns on indigenous peoples in Taiwan?
I mean, in particular, on the question of nuclear waste, we had a longer discussion about the timeline when nuclear waste will be removed. The answers was that it's not so easy to find another place. You have to consult the communities, etc. Do you have any any comments on whether there is enough done by the government to actually implement our recommendation of removing nuclear waste from indigenous people's lands?
Regarding the relocation of nuclear waste, we have heard some discussions about identifying another site, yet such sites are still within indigenous land and territories. To find such a candidate site, of course, the consultation and consent must be obtained from indigenous communities. Yet again, the procedure was very rough. And before members of our community knew exactly what the impact would be, referenda was held. Fortunately, because there were so many controversies, the referendum wasn't held. However, at that time, most candidate sites are still within indigenous land and territories because Taiwan has very small land, and indigenous people's territories are less densely populated. So before the plan for relocation is completed, the government is already beginning to discuss that they would like to recommissioning the second and third nuclear power plants in Taiwan. So I don't think they are ready to discuss the relocation site issue.
Your opinion, would there be suitable land outside of indigenous people's territory for the relocation of nuclear waste?
我是人权公约事情监督联。
Covenants Watch speaking. In the low-level radioactive nuclear waste in Orchid Island is yet to find a candidate site. There's one in Daren County in Taichung. However, it is still within a indigenous people's territory. So maybe some offshore islets. Orchid Island, of course, is an offshore island. That is where low-level radioactive nuclear waste is stored. But aside from that, maybe other offshore islands or other countries. Otherwise, if you're talking about Taiwan, then there will be controversy, or most likely the site will be within the indigenous traditional territories. In addition, 2 years ago, people began to discuss whether we would like to extend the life of the third nuclear power plant. However, that proposal was not approved by the referendum. So according to the referendum, the third nuclear power plant cannot be be reused, be reopened and reused. So now the third nuclear power is not functioning. However, during that referendum, a lot of people voted for the continued operation of nuclear power plants. That's why President now is thinking about maybe we should restart the nuclear power plant operation, or even the extension of the life of the second nuclear power plant. In that case, we're going to have more high-level, highly radioactive nuclear waste that we have to deal with. So we would like to recommend our government be cautious not to restart using nuclear power plants liberally, because that may result in more suppression of indigenous communities.
You? Any other responses to these questions about nuclear waste? Luca, would you have other questions?
Yeah, I just want to remind us that we are here not to assess the situations of indigenous peoples based on the constitutions or based on the existing legal framework in Taiwan, but we're here to analyze or to see the situation based on the international human rights law. That's why we're here. So that's why later on what we are going to provide is our comments based on the existing human rights law and the for example, in UNRIP, it says that indigenous people's land and territory is not the subject for militarization, and also is not the subject for a militarization, including military training camp, and also not for a nuclear. It's not the subject for a experimental, like technology experiments, unless indigenous people said so through free, prior, and informed consent, which I don't see. I have also mentioned this earlier to the CIP that the new draft on free, prior, and informed consent has to be in cooperation and in full and effective participations of indigenous peoples. That's the one I want to. I also want to reiterate the study by the UN Special Rapporteur on the Rights of Indigenous Peoples on the political rights, the rights to voting and elections, the concerns about referendum. Yeah, the referendum when it comes to the public issues like energy, referendum is fine. But when it comes to any project that will impact or there will be in indigenous peoples, nationwide referendum cannot be applied because it is already putting indigenous peoples on the losing side. So that's, I think, let's remind all of us about that. I think that's so far from me. Thank you.
Equality and non-discrimination issues. Are there any concerns from your side that we have not yet taken up? I think I have 1, 2, 3. Please.
Good afternoon. So I'm speaking on behalf of the National Association of Equality for Life, Taiwan. During the previous reviews, the reviewers recommended that Taiwan government protect people's right to life. We respect your stance, and we respectfully ask you to also consider Article 1. That is how many obligations Taiwanese government has fulfilled for the protection of victims' life.
And the fulfillment of such protective obligations include many things, and how many of such obligations include the procedure obligations for the family members of the deceased of the victim. If you think this is an issue for Article 2, effective remedies, I want to ask you, what do effective remedies mean to the family members of the victim? If you think this is an issue of Article 26, equal protection, then I want to ask, why are defendants protected by law in every procedures, while the family members of the victims have no legal status in any procedures? Is that treatment compliant with equal legal protection? We joined this review meeting and expect that through the review panel, we're able to improve the equality between the rights for victim and the rights for defendants, because currently there's a huge gap. We also want to improve the transparency of the laws and regulations. We hope that victims' status in the procedures can be improved. I also want to add by saying yesterday, some other organizations said that at the beginning of 2025, there was a sudden execution of death row inmates. I want to say that in terms of procedural justice, administrative rules must not override judicial verdicts. Remedies doesn't mean that you're able to block the execution of the law. Thank you.
Thank you very much. I have 2 and 3.
不好意思，我只快速的再补。
I want to add very quickly about Orchid Island nuclear waste, because the reason why it has been neglected throughout the years is back in 2019, TPC will provide retroactive compensation. They plan to give away $2.5 billion to the residents in Orchid Island. And outside that storage sites on Orchid Island, on a daily basis, they make public the level of detected radioactive materials. But I want to emphasize that we've never been able to see whether the government does any research on whether or not the indigenous health was impacted. So it seems that so we hope that the committee can add another recommendation about health. Maybe it's more related to Article 25, the right to health. We hope that while the government hasn't moved away the nuclear, they should be following the health of the indigenous peoples on Orchid Island.
Distinguished committee members, I represent the Association of ROC Citizens in Taiwan. Regarding the principle of equality you mentioned earlier, unfortunately, in Taiwan, the government still uses various means to discriminate against religious and spiritual groups. Unlawful taxation is one of the most prominent examples. First, the issue of performance targets. To meet their quotas, tax authorities often issue bills without conducting a thorough investigation. This leads to frequent errors in illegal tax assessments. Second, the lack of legal remedy. Even when new evidence proves a tax order is illegal, the Taiwanese judiciary often rejects retrials based on procedural grounds. Likewise, administrative agencies refuse to reopen cases using various excuses. And this leads to the auctioning of their property, land, and homes. The most iconic example is the Taijimen case, which the Control Yuan has identified as a major human rights violation. Because the administrative courts and tax authorities refused to apply international human rights covenants. This case has dragged on for over 30 years without a true remedy. We urge the committee members to look into these practices and hold the government accountable for these violations of international covenants. Thank you so much.
Thank you. Please.
Committee members, thank you. I represent the Association of World Citizens. In continuing with the concern of discrimination unjust in a system that fails to apply the ICCPR outside of the juvenile courts, I here raise a serious unresolved concern: the perpetual endless tax bills, 万年税单. So in Taiwan, the tax system is built in a way that even a taxpayer, whenever they win in court, the original tax bill is not canceled. The tax authority simply recalculates the issues and issues a new tax bill, again and again with no limits on how many times. What makes this especially troubling is that the cycle is triggered precisely in cases where the court found the tax authority was wrong. The Control Yuan investigated this in 2022 and concluded the system is fundamentally broken. 136 tax cases trapped in this endless cycle. In just 5 years, 29 cases continued for over 10 years. The Taijimen case, supported by scholars both in Taiwan and internationally, has won multiple rounds of administrative relief. And yet, after 30 years, effective remedy has still not been achieved. This leaves taxpayers with no finality. The endless wait has caused immeasurable suffering to countless victims. This directly violates ICCPR Article 2, Paragraph 3, the right to a genuine and effective remedy, against international human rights standard. We have exhausted domestic channels. We are standing here before this committee with you all having the power to end this suffering. Thank you.
Thank you. Would you like to respond to the first question?
Sorry
Okay.
to bother you.
Yes, please.
会议提醒，请发言人员注意语速，以利口译和原翻译，谢谢。
There was an announcement to remind all the speakers to pay attention to their pace for interpretation.
Yeah. I've made this appeal already before, but now I didn't realize that it was too quick. Shall you try and I can...
A question about the participation of victims in criminal proceedings. Well, this is a difficult matter because the practice in different states varies considerably about the level of participation of victims in criminal justice proceedings. And I think the Human Rights Committee has been hesitant to be too prescriptive about what that should be. I think that we have case law from the Human Rights Committee recognizing the importance, for example, of the 1985 Declaration on Victims in Criminal Proceedings. We also have the very robust concept of procedural obligations in the case of violations of articles of the right to life and of the prohibition of torture and ill treatment. So the right of victims to see that justice is done, including criminal prosecution, is quite firmly entrenched in the case law. I think the issue then is simply the level of participation, and I'm reluctant to answer more without having a full briefing on it, and we haven't had this from the government either about what they are doing, but I think it's clear that there has to be meaningful engagement of victims in the proceedings. I think that's as far as I really want to go on this. Maybe my colleagues have more to add on it, but this would be.
But there is also a particular Crime Victims Protection Act in Taiwan, which provides compensation for the families of deceased victims. And then, of course, the participation is on the one hand in a criminal trial, but there might also be in civil proceedings that victims do have a right to claim compensation against the perpetrators of a crime. But if you would like to add anything, you're most welcome. Please.
Committee members, I want to speak about the different legal differences between victims and defendants in terms of remedies, I mean. So a defendant can apply for retrial and ask for extraordinary appeal, and they can ask for constitutional interpretation. They can ask for exemption or immunity. They have mandatory defense. They can engage in verbal arguments. And then the seventh, which I think is the worst, is the consensus or unanimous decision from the 2024 constitutional judgments. And there are no such protection for victims. We don't have petitions that can be protected by the legal framework, and the mental counseling is ridiculous. Compensation and the media exposure is very limited. I want to ask you, are we equal? Are victims equal before the law? You mentioned some rights of the victims. What we only ask is just to be delivered. Judgment shouldn't be only live on the paper. They should be executed. They should be implemented. That's our only expectation. Thank you.
We'll be later, I think tomorrow, dealing with Article 14 of the International Covenant on Civil and Political Rights. But it's very clear that in the architecture of international human rights law, in the main treaties, both the Covenant on Civil and Political Rights and the applicable regional treaties in the Universal Declaration of Human Rights, particular attention is given to the rights of people who are accused before the criminal justice system. And I don't think it's, personally, I don't think the way to approach this is to suggest that there is some sort of equality of rights between the victims and the accused. The victims have other rights, including rights to reparation, that probably in some ways are stronger than those of the person who's accused. but it's a different, I don't think we can just suggest that they should be equated, and that if certain rights are given to an accused person confronting the criminal justice system, that there has to be some mirroring of those rights with respect to the victims. But I think that, and my colleagues have pointed out, that there is legislation for this. It may be inadequate, and we could discuss the types of reforms that might be recommended. But yeah, I don't think the objective and the proper framework for dealing with this is to suggest there is some sort of equality of treatment of the accused person and the victims, because the circumstances are quite different, and the reality of the situation they confront is quite different as well.
Thank you. Would you like to react to Covenant's Watch on the Orchid? This retroactive compensation that you feel has not been implemented in a satisfactory way.
But because of the huge amount of compensation, I think this issue has been neglected. Yeah, but I just urge the International Review Committee to come up with a piece of concluding observation, asking the Ministry of Health or the government should, to do a long-term follow-up on the health and the longevity of the people of the Orchid Island, and to make a meaningful comparison with that of the Taiwanese people as a whole. Yeah.
That's, I think your recommendation earlier to have the review of the health status of indigenous peoples in that impacted by that nuclear waste, right? And I think there's also needs to be the transparency of how the money has been used and distributed, because we have also I have also received some issues of the misuse of, or not misuse, but the money went to groups that actually they don't deserve. So the deserving community don't get what they deserve, but actually goes to other parties who are not impacted as much as they were impacted. So I think there are two issues, like transparency of the use of the compensation money, and also the health, the study on their health status of these impacted communities. Yeah. Thank you.
On the taxation of and discrimination in relation to religious groups by taxation, I think we have dealt with in earlier review meetings with these particular cases, but I guess that you also have submitted a written kind of presentation of this particular case. Then we would have to look into it in more carefully, if that is okay with you. Any other issues that you would like to raise, please?
你好，这边是。
So I speak on behalf of the Taiwan Sex Industry and the Workers' Rights Association. I know in this session you talk about some gaps in government's data, statistics, or intersectional discrimination among different groups. So I wonder, in your concluding observations, maybe you can also highlight the invisibility of sex workers. Sex workers very often have intersectional conditions with indigenous people, migrant workers, or gender, transgender, etc. And of course, this is subject to the Article 26, equal protection of the law. I think Taiwan's government and civil servants sometimes may be lazy. They need to be nudged or prompted by international reviewers before they would take concrete actions. For example, right now, the MOI or the Central Police Agency would look at the crackdown data. The National Immigration Agency focuses on the number of deportations, and the Ministry of Health focuses on the number of disease or STIs. There are few mechanisms to go across different departments and ministries to look at the issues and problems of sex workers. It's not that we don't want more, regulations or control. Rather, we also want to have equal protection of our rights, so that judicial remedy, right to health, housing, work can be ensured. In fact, in the year 2011, there were proposals to set up dedicated red light zones at local government, thus giving legality to sex workers in that place. However, so far, no local government has set up such red light zones at all. So sex workers continue to be penalized by law. So we hope the government can draw lessons from Belgium, New Zealand, to decriminalize sex workers so that the right to work of sex workers can be better protected. So we hope you will include such opinions in your concluding observations. Thank you.
Thank you. Did you provide any kind of written submission?
Yes. We have submitted our opinion in the parallel report, but in the national report, it didn't mention sex workers at all.
Please.
Good afternoon. I speak on behalf of the TAPCPR, focusing on LGBTQI communities' rights. I think when government formulates policies, they should consult the opinions of the LGBTI or disadvantaged groups. However, we've found that government in formulating policies, even though they may have huge impact on LGBTI community rights, the process has never involved members of these community. For example, the Ministry of the Interior recently announced that there will be different rules to determine the draftees' health status. There are some rules concerning, say, bisexuals and uncertain or intersexual category, and there's also the transgender category. And for people who fall into this category, they can do alternative military service. So before this policy is announced, members of this community have never been consulted. NGO representatives rushed to have meetings with members of the community and produced responses to the government. So we protested and the government heard us. We would also like to talk about the mandatory surgical requirement for legal gender marker change. This requirement remains. So for so many years, we have been promoting the abolition of such a requirement, yet the government has never asked for our input. In other words, when the government is formulating policies, they overlook the need to consult those who may be impacted by the new policies. And I think you have heard that many reports show that even though same-sex marriages have been legalized in Taiwan, however, there are still inequalities when it comes to sexual orientation. For example, for two foreign nationals who are heterosexuals, they can be married in Taiwan. Their marriage can be recognized here. But for same-sex couples, if one of them come from a country where same-sex marriage is not legal, their marriage is not recognized in Taiwan. Yet in Taiwan right now, we have a lot of foreign nationals working, living, studying here, but their right to marriage as a result has been restricted. Another issue is about the artificial reproductive technology, ART, for heterosexual married couples. If they have children, even if they are born out of the wedlock, basically the children are recognized. But for same-sex couples, their children will still be regarded as born out of wedlock. As a result, the child is deemed to be in a family of single parent. And the situation is even worse when foreign nationals are involved in the same-sex marriage.
Please.
我是袁元萌，不好意思，我想要最后
Covenants Watch speaking. I have a follow-up comment. That is the public participation issue. In 2013, in your concluding observations, you already pointed out that government should have more consultation with citizens in formulating policies. But I have to say, in the past couple of years, the situation has become worse. In the previous session, you heard that FPIC has very clear definition, but the government does not consult the public until the policy is almost 80 or 90% ready to go. And I think that, of course, contravenes Elster, a social scientist recommendation, that is, we should have a funnel kind of consultation. You should consult as many people as possible at the very beginning, and then with a draft, you can seek input from the general public again. But now, public participation and consultation in this stage in Taiwan is very much lacking. As a result, they tend to be rather formalistic because by the time you are consulted, there's not much you can do to change the policy the government has decided on. In addition, if we come to the second phase of public consultation, for groups or communities, the new policy is going to have a huge impact on. Usually, the government will pick groups, organizations that tend to align with their stance to join the consultation sessions. In addition, when they have meetings with NGOs, they invite a wide spectrum of NGOs. As a result, the opinions tend to, offset each other. As a result, the bill or act is passed, especially for environmental evaluation acts or regulations. without participation of the stakeholders, the law cannot be passed, or even if it is passed, it is illegal. But now we do not have administrative procedures which emphasize or make it mandatory. Certain regulations or policies must have had civic consultation before they can go ahead. So I hope you can highlight the importance of public participation in your concluding observations. Thank you.
We are running out of time, but I have still one request for the floor.
This is Taiwan Mothers Shield Alliance. I want to talk about equality and non-discrimination. I think there's some errors about the sequence or the order, because we're talking about the laws, but there are already many laws in Taiwan which include the idea of discrimination. But it seems that we're still feeling we're lacking of something. We're lacking of an anti-discrimination act. We haven't been doing is providing education. If we haven't done enough education or teach things at the right place, then the results, in fact, are worse. For example, gender mainstreaming is a policy. So in many policies, well, recently I know there is a university club. When they organize activities, they can, if they organize LGBT activities, they can apply for funding for the club. So other clubs think this is unfair. So in private, students from other clubs say that, okay, we can also organize a LGBT something something activity. I think this is not helping children to understand equality and non-discrimination. The education is not in place. Children are not really learning respect and equality. So I think there should be more focus on education instead of creating more laws.
Thanks very much. We are running out of time. I think many of the issues that you have raised now are already on our agenda. We have included them in the list of issues, and including the Anti-Discrimination Act and also the discrimination against the LGBTQ plus community. On the mandatory surgical requirement for gender identity, I have understood that this requirement has been abolished. If that is not the case, we will, of course, take it up. Thank you. Please.
Just add that that issue and other issues you raised will arise tomorrow.
Okay, you have the last word so that you...
Hi, I'm from National Association of Equality for Life Taiwan. I'm the director of this association. Even though you already said that for victims, the states, different states have different ways of doing things. But in Japan has laws to protect and to compensate a victim, but this is lacking in Taiwan. So I want to add that. Also, the laws in Taiwan should be done by a legislative yuan that suits the Taiwanese people. I have a question for you. If a police officer is an executor of the life and the police officers themselves are killed and the defendants are not sentenced to death penalty, who will be left to protect our laws? Because in Taiwan, the order of Taiwan is protected by the police officers, not by the alliance to end death penalty. I want to say this again. The order in Taiwan is protected by the police officers instead of the alliance to end death penalty. So that's my question for you. Thank you.
I think you know our answer very well. Thanks very much, and that concludes this session on Indigenous peoples' self-determination, minority rights, and equality and non-discrimination. In the afternoon, we will continue with Article 6, Article 7, that's about the death penalty, and many other issues, torture, inhuman and degrading treatment, but also Article 8, that is the prohibition of slavery and slavery-like practices, forced labor, and Article 9 and 10, the rights to personal liberty, and that also includes prisons and prison conditions, conditions of detention. So there are many of those issues can again be brought up. Thanks very much, and see you again in the afternoon.
本场次会议备有餐点，请至。
Lunch is provided after this session. The afternoon session.
ROC's fourth ICCPR review meeting, session 3. We're going to cover ICCPR Articles 6 to 11 and concluding observations and recommendations, paragraphs 67 to 81. Now, the meeting commences now. Please pay attention to your speed of delivery so as to facilitate interpretation. Please identify your affiliation and turn off the microphone after you finish your remarks. Thank you.
All right. Thanks very much. Welcome again this afternoon. We are covering quite a number of important articles of the Covenant on Civil and Political Rights, the right to life in Article 6, prohibition of torture and other forms of cruel, inhuman, or degrading treatment or punishment. In Article 7, then Article 9, prohibition of slavery, servitude, forced labor, etc. And Article 10, which is a very unique article which we don't find in many other regional treaties. That's the minimum conditions of detention, and in particular also the very purpose of imprisonment. And Article 11, the prohibition of imprisonment for debt. So we go article by article and start with Article 6, the right to life, and there I pass on the floor to my colleague, Bill Sherbers.
Thank you, Manfred. I'm going to confine my remarks at this point to the 4 paragraphs in Article 6 that deal with capital punishment. I'm going to speak to the issue of the death penalty. Some of you may be aware that the United Nations issues a report every 5 years on the status of capital punishment. And the last report appeared a little less than a year ago during 2025. I'm very familiar with the reports because I have prepared for the last 15 years the draft for the Secretary General, which is then revised internally and issued. The reports first started dealing with Taiwan distinctly in 2000. These reports have been prepared since 1974. So we, this year, had the 11th report. And so it was only in 2000 that the report first addressed the status of the death penalty in Taiwan, which is identified, as you probably know, as Taiwan, province of China. That's the official designation in such UN documents. And the report assesses the status of the death penalty over the previous 5-year period. So the 2000 report, the report for 2000, recorded that Taiwan had conducted 121 executions over the previous 5 years. The next report in 2005 recorded 67 executions, just a little more than half of what there had been in the previous 5-year period. And the report in 2010, this was the first one that I was responsible for, reported only 6 executions. So it had gone in the space of 10 or 15 years from 121 in a 5-year period to 6 in a 5-year period. And then there was some increase, nowhere near the earlier levels, but it went up to, in 2015, to 18 executions. And 2020, which was a report for the period from the previous 5 years, 13 executions. And the 2025 report that I drafted said there was only 1 execution in the period. That was the execution in 2020. Of course, we know that the next report, 5 years from now, I don't know if I'll be the person to prepare it, but I do know that it's going to record that there'll be at least one execution in Taiwan because it took place recently. And I would like to think that, I would hope that maybe that will be the only one that's recorded. We had said, and it's referred to in the question we asked in the list of issues in 2022, that the situation, the failure to proclaim a moratorium was profoundly unsatisfactory. And I won't speak for my colleagues. We'll decide what to say in the concluding observations later this week. But I would be surprised if we don't take a similar tone given the situation in Taiwan at present with regard to the death penalty. Over the period that I've been preparing the reports, most countries that have the death penalty have recorded declines in the number of executions. Taiwan is no exception. It's actually a fairly consistent pattern. A few countries have recorded increases. Iran has recorded increases. The United States of America this year records a significant increase in the death penalty since the election, since the new administration came into power. But in 2010, there were 46 states reported in the UN report that had the death penalty. And in 2025, there are 30. So 1 out of every 3 states that has the death penalty abolished the death penalty, became an abolitionist state. Taiwan could join the list. The United Nations records states as being abolitionist if they've abolished the death penalty in law or if they have stopped executing either for a period of 10 years or have declared an official moratorium. Taiwan would leave the list of retentionist countries if it were to declare an official moratorium, as was recommended in the concluding observations 4 years ago. I think it's worth thinking a little bit about the regional situation, because the regional situation demonstrates quite mixed attitudes towards capital punishment. Neighbors of Taiwan, immediate close neighbors, South Korea, still has the death penalty in law, but it has not conducted an execution since 1997, 29 years. The Philippines is about the same, although it has actually abolished the death penalty in law. That was in 2000. The 2 countries that are neighbors that execute, of course, are Japan, a relatively small number, but there's a steady record of executions in Japan, and then the People's Republic of China, of which we don't know the numbers. We just don't, they do not make them public, and we don't know how many executions are conducted there. I think it's also worth reflecting on the fact that even within the borders of the People's Republic of China, there are 2 units, 2 political units, Hong Kong and Macau, that have no death penalty. So of China's neighbors, of the 6 political entities that are neighbors, 4 of them are not using the death penalty. And that's, not without significance, it seems to me. We could speak even of, I don't know if this is politically correct, but of the Mandarin-speaking political bodies in this region, of the 4 Mandarin-speaking political bodies, 2 do not have the death penalty. 1 executes very rarely, and the other executes, it would appear, very frequently. We've been told, and it says this in the answers to the list of issues, that the Constitutional Court ruled that the death penalty is conditionally constitutional. This is on page 119 I've read the materials on the Constitutional Court decision, and I actually didn't get that message. I got the message that the Constitutional Court had established some restrictions on the use of the death penalty, but I think it's a misunderstanding of a judgment to suggest that in imposing limits on the use of the death penalty, it is also thereby endorsing or approving of the death penalty. This is a problem that we have in the interpretation of Article 6 of the Covenant. Some states, not a large number of them, but some states contend in the United Nations that the death penalty is authorized by the International Covenant on Civil and Political Rights because of the limitations on the death penalty's use that are established in paragraphs 2, 3, 4, and 5 of Article 6. A plain reading of Article 6 shows the defect in this analysis because paragraph 6 is very clear that nothing in the article should be invoked to delay the abolition of the death penalty. It makes it clear that states that have the death penalty should be headed towards its abolition. Nothing, those 4 paragraphs that deal with limitations on the death penalty, in other words, cannot be invoked as a basis for an argument that the covenant endorses or approves of or allows the death penalty. The covenant says in paragraph 1 that no one shall be arbitrarily deprived of his life. That's the principle. And then in paragraph 6 it says that nothing in the text of Article 6 can be interpreted in such a way as to delay the abolition of the death penalty. That paragraph 6 would not be there if it were not for those other paragraphs 2, 3, 4, and 5. It is directed at those other paragraphs. The idea that a human rights treaty limits the use of certain activities does not mean that it endorses them. This is not the same as the kind of limitation that we see put on fundamental rights, for example, when we talk about freedom of expression or freedom of religion or freedom of peaceful assembly or freedom of association, where the rights are being defined in such a way as to take into consideration other factors, including the rights and freedoms of others. It's an attempt at defining the right. But when we have paragraphs 2, 3, 4, and 5 in the covenant that speak of the death penalty, they are not there to help define the right to life. They are there because when the covenant was adopted, a significant number of states still use the death penalty, and it was important in a human rights treaty to ensure that limitations were imposed on the use of it. We have other examples of this in treaty law that I can point to. In a few minutes, Professor Novak's going to talk about the Article 7 of the Covenant, but I would expect he may also refer, he already has done so yesterday, to the Convention Against Torture. The Convention Against Torture sets out the prohibitions on the practice of torture. It also deals, but rather more briefly, with cruel, inhuman, and degrading treatment or punishment, and it imposes limits. This is not an endorsement of cruel, inhuman, and degrading treatment or punishment. It does not mean that the United Nations and that the treaty is in some way authorizing the imposition of cruel, inhuman, or degrading treatment or punishment. It's simply a reality of the treaty negotiation that in order to get a text that is acceptable, you sometimes put limitations on, in certain areas, on practices that are themselves contrary to the treaty in question. There are other examples I could point to, and it's the anniversary this year, the 100th anniversary of the Slavery Convention. The Slavery Convention prohibits slavery, and then it talks about how the authorities can regulate compulsory or forced labor pending the abolition of slavery. It's rather like those paragraphs in Article 6 of the Covenant. It's not approving of compulsory or forced labor. It's not authorizing compulsory or forced labor. It is saying we can prohibit slavery altogether. As far as compulsory or forced labor is concerned, we're going to impose some limitations on it because we cannot get the states to agree in this context to a treaty and will not accept a treaty where this is abolished. We even see it in the Charter of the United Nations, where we have Article 73, which imposes limitations and restrictions on what states do in what were once called non-self-governing territories. The polite term used in the Charter of the United Nations for colonies. The Charter of the United Nations is not giving its blessing to colonies. That would have been unacceptable. But it's saying as long as those colonies exist, they are a reality, and we will regulate and govern and restrict what states who are what were called the administering authority, the colonial power, was doing in the colonies pending abolition. In the answers to the list of issues, the explanation is provided, this is at page 119, that any decision on abolition or retention must be premised on a social consensus. And I noted this morning that this is also set out in the paragraph dealing with Article 3 of the Covenant that speaks about abortion, saying that that would also be legislation on abortion would have to follow some kind of a social consensus. I don't know that this is really the most helpful way to proceed. I understand, of course, that governments have to be sensitive to public opinion, although sometimes they do have to take unpopular decisions, and sometimes they decide to do things where there is no consensus, and maybe there never will be one. Well, I don't know that you'll ever have a consensus on abortion, for example. The fact is you have legislation on it that is probably not thought of as being appropriate by a large number of people in the country. I don't quite understand why, when you say there's a lack of social consensus, that the default of that observation is the status quo. That's one problem here. More generally, when it comes to criminal justice, we're almost always going to have differences of opinion about what should be criminalized and how harshly it should be, what the penalties should be, and the rules that apply to it. So I think that the idea that you have to have a social consensus on these matters is not necessarily the way to proceed. And above all, for our task here, monitoring the implementation of the provisions of the International Covenant on Civil and Political Rights, we're not asked to determine the social consensus. We wouldn't be able to do that anyway, given our limited knowledge of the reality in Taiwan. We're here to determine whether it's in compliance with the Covenant on Civil and Political Rights, with the provisions of the Covenant on Civil and Political Rights. And I think that we should conclude that the death penalty, in my view, is inconsistent with the Covenant on Civil and Political Rights, with paragraphs 1 and 6 of the Covenant on Civil and Political Rights. And also, of course, but this is for a little later this afternoon, Article 7 of the Covenant on Civil and Political Rights. In the answers to the list of issues, and then I'm referring here to page 118, there's reference to a consultation of public opinion that was undertaken. And we heard reference to it, I think yesterday there were a few references to this survey, and it's commonly expressed that 80% of people in Taiwan support the death penalty. or are opposed to abolition of the death penalty. I don't really believe that. I don't think that's probably true. I think that you have not conducted surveys according to scientific methodology of criminologists, of proper, sophisticated polling to determine public opinion. I'm not just inventing this. We've seen public opinion polls like this in the United States, where they still have the death penalty in some parts of the United States and where they execute many more people than Taiwan does. And people sometimes say, yes, we did a public opinion poll and it shows that 80% of Americans, it's a similar number to what you found here, 80% of Americans want the death penalty. But it turns out that when the questioning is a little more sophisticated and a little more subtle, that we don't get the 80% number. It drops to below 50% when people are asked whether they would accept as an alternative to the death penalty a lengthy term of imprisonment as punishment. And then in the United States, as well as in other countries, it drops to below 50%. So that's the United States. But about 15 or 16 years ago, I was part of a project to do a survey of public opinion in the People's Republic of China, in mainland China. And this was done with 2 universities in China and with the Max Planck, one of the Max Planck Institutes in Germany. So it had, you know, the state of the art in terms of the methodology of doing a public opinion poll. And the results, which were presented at a seminar in Dalian, I think in 2008 or 2009, were quite stunning because they showed that public opinion polls in China give the same result. In other words, if you present to the public that you have a serious alternative to the death penalty in the form of a lengthy term of imprisonment, the support falls below 50%. I think that if the government here was more proactive in that way, in attempting to find the evidence, really to probe public opinion to see if public opinion could be convinced to support the abolition of the death penalty, you would find that the circumstances are not as dire as is presented here in the list of, in the answers to our list of issues. This is why I say I don't really believe the figure. It doesn't correspond to what we see in other countries. And I think that you probably need better, more sophisticated pollsters. And I would be very surprised if you don't get a similar message. And again, when we talk about the neighboring countries in the neighborhood, we see that there are countries not far from Taiwan that have, or political entities that have abolished the death penalty and are getting along fine, and where there's not great social turmoil as a result. A final comment, the death penalty is really an emblematic issue in terms of international human rights law. Taiwan is going through this exercise both for the people of Taiwan so that they have protections for their fundamental rights, but also, and I think this is perhaps why we're here from outside the country to do this assessment for Taiwan's profile globally, for its profile in Asia and globally as a country that protects fundamental human rights. And abolishing the death penalty is extremely important in terms of that public profile for reasons that maybe we don't even fully understand, but it's a fact that this will put you in the category of states that have made that advance. Because it is an advance. It's clearly not just a policy decision with no consequences. This is an advance in the protection of human rights. We've seen it since these initial reports every 5 years were done in the 1970s. at a time when a majority of the states in the world had the death penalty, to a situation now where 30 countries out of approximately 200, 30 countries still retain the death penalty, and of those 30, only about 10 of them use it in a significant manner. And it's very unfortunate that Taiwan, which wants to present an image of a country that's, that protects fundamental human rights, is in that list of 30 countries. You should be in the list of 170 countries. Thank you.
Thank you very much. You haven't really put a question, I should say. But nevertheless,
Why?
Who would like to respond to the statements, and I would say very strong and convincing statements from a human rights perspective on the death penalty? Please, who would like to take the floor?
Thank you for your question. I'm from MOJ, the prosecutorial office. Regarding the execution of death penalty in Taiwan, well, since the execution will lead to the irreversible result of the loss of life, and therefore our country is very careful with the execution and the review of death penalty as well. There are opportunities for the death row inmate to exhaust all possible legal approaches before execution is approved. As you mentioned, the numbers of death executions have dropped significantly from 2020 April to 2025 January. There's a span of 4 years without any executions. The last execution in 2022 to the next finalization of death penalty took 6 years. So these objective numbers indicates that Taiwan is very serious about the right to life in the covenant, the ICCPR covenant. In the judicial practices, it has been realized gradually. And the Judgment 8 from 2004 states that a death penalty is constitution with conditions. And since in the substantive law in Taiwan, there is still the offense. There is still a death penalty, and we are a country of rule of law, so we have to abide by the law. That's our fundamental principle, and that's the attitude and the perspective of MOJ. And therefore, the current death penalty policy allows the exhaustion of all the administrative procedures and legal examination before any executions are approved. And you mentioned public pause. Death penalty has to consider complicated factors in the country, including political, social, and historical factors. And based on historical polls, there have been multiple public polls. So as high as 80% of the people think that death penalty should be maintained. But the previous poll was a while ago. So in the recent 2 years, the MOJ has done further public polls. And these public polls do include alternatives in the questions. After the pause, the number actually grows from 80% to 90%. 90% of the people still supports death penalty. And if we use life imprisonment to replace the death penalty, is it possible to reduce the percentage? But that alternative results in the 59%, around 60% of the people who indicate that they are unwilling to support abolition. This is my remark. Thank you.
Are there any other responses? Please.
Judicial Yuan speaking. On the Constitutional Court Judgment 8 of 2024, I would like to provide more contextual information. The death penalty issue is rather controversial in Taiwan. Before the Judgment 8, the great justices dealt with the constitutionality of the death penalty. And then in 2024, the great justices decided to take the case again. It is a huge challenge for justices. And in the end, they still believe that it is conditionally constitutional. It is only with very stringent procedural safeguards that execution can take place, including substantive and procedural safeguards. Even so, great justices did not deny the constitutionality or legality of the death penalty. Even so, the Judgment 8 still caused a lot of uproar in Taiwan. As you heard from the opinion poll result, when the Judicial Yuan followed the Judgment 8 of 2024 to make some amendments to existing laws, we faced a lot of opposition and resistance. For example, according to Judgment 8, basically, all judges have been following the content of Judgment 8 for years, but we at the Judicial Yuan still need to amend the relevant laws, and the amendments are still being reviewed by the Executive Yuan. I think yesterday, Constitutional Court crisis was mentioned, and I think to some extent, the Judgment 8 of 2024 is at the heart of many controversy surrounding the Constitutional Court. Therefore, Taiwanese society's attitude toward death penalty is not fecal. It's not something that is fecal or temporal. It's definitely a challenge we have to tackle head on.
Thank you very much for that additional information regarding the context of the constitutional crisis, which is most helpful for us. As Professor Novak explained yesterday, we are, of course, not here to judge opinion polls. However, I think it's important that we understand opinion polls to the extent that we can. So in terms of the poll, what I would like to know is there a difference between urban and rural populations? Is there a difference between the younger and older populations? Is there a difference between men and women? Does the polling go into that detail? Or does the polling instead look at death penalty or alternative heavy sentences? So if you could give us a little bit more information on the population and how it stands in the poll, it would be most helpful.
Please.
MOJ, Department of Prosecutorial Affairs. The survey, aside from the question on the abolition of death penalty, pros and cons of abolishing death penalty. Moreover, we commissioned a third party to conduct this poll, and respondents included citizens aged over 18 and over, and also prosecutors, judges, lawyers, and law professors are also included. Elected representatives, including legislators, city councilors, were also included. In addition, inmates were also included, including those who are doing their time for sentences longer than 5 years. Also, the parolees on probation were also included in the survey. 3,569 responses were collected. Again, on the specific result of the poll, I think I have covered them in my previous utterance. Thank you. Specifically, yes, men and women, age, they are all included in the demographic profile of the respondents.
What you've told us is really that it's a wide pool of citizens, but it's not a calibrated poll. We don't know then what the difference is, or if there are any differences between age groups, men and women, social class, etc. But thank you for the information that you've provided. In itself, it's helpful. Thank you.
Yeah, let me perhaps move also to Article 7 and Article 10. And I mean, we have been discussing this issue now for more than 10 years. We started in 2013, and our recommendations have been very, very clear. When you look at Article 7, it says no one shall be subjected to torture or other forms of cruel, inhuman, or degrading treatment or punishment. Again, that is from 1966, in the European Convention from 1950. That was a time when the term cruel, inhuman, or degrading punishment or treatment was still interpreted in a totally different way. In most countries, whether it's in Asia or in Europe, corporal punishment was still applied in the courts, by judges, in schools, by parents, etc. It was seen as a normal form of education, and in particular in the juvenile justice system, it was seen as an even lighter punishment than imprisonment, until the European Court of Human Rights, and the former president is sitting next to me, has decided in a very, very famous case, Tyra versus the United Kingdom, that even a fairly light corporal punishment as a judicial punishment on a juvenile. Just 5 strokes on the naked buttock was considered a degrading treatment. And degrading treatment is as absolutely prohibited as torture or inhuman treatment. And that was the beginning of a global reassessment of what inhuman and degrading punishment actually means. There were later judgments in the European Court of Human Rights about corporal punishment in schools, in public schools, and even in private schools. And again, the court developed that jurisprudence, and it was followed by the Inter-American Court of Human Rights and by the Human Rights Committee of the United Nations, to the point when jurisprudence clearly says every form of corporal punishment, light forms or heavy forms like amputations, stoning a woman to death, etc., every form of corporal punishment is today absolutely prohibited. Now, isn't capital punishment the worst form of corporal punishment? Why did the courts wait for quite a long period of time to clearly say capital punishment is an inhuman and degrading punishment? Because you also had the right to life. And under international human rights interpretation, the Vienna Convention, the law of treaties, you need to apply a systematic interpretation. So if Article 6 of the Covenant still allows for certain reasons, exceptions to the prohibition of the death penalty, how can then Article 7 be interpreted as absolutely prohibiting? That would be a contradiction. Even more in the European Convention, because Article 2, the right to life in the European Convention, is much broader. You only need an independent court and a criminal provision, but it is earlier. So in the meantime, the interpretation, the meaning of the term inhuman, cruel, and degrading punishment has changed on a global level. And that is the main reason why most states feel that they have to abolish the death penalty, because it is, and that is today confirmed by so many courts in the world, the strongest judgment, in my opinion, is the one of the South African Constitutional Court of 1995, where the South African court clearly spelled out that every form of capital punishment is a violation, a serious violation of the main right and principle of human dignity. And that was done in reaction to decades of the apartheid system, the white rule against the black people, and most people who were sentenced to death were black Africans or colored people. But also the European Court of Human Rights at a certain point changed and said the very fact that people are sentenced to death is a violation of Article 3 because it is an inhuman or degrading punishment. The same was said by the UN Special Rapporteur on torture. So today we are on very, very clear grounds, including the Human Rights Committee of the United Nations, which is composed of independent experts from all over the world, clearly saying, irrespective of what is written in Article 6, it's perhaps not a violation of the right to life, but in any case, it's a violation of the right to human dignity that is established in Article 7, the prohibition of inhuman and degrading punishment. So we are not anymore talking about, is capital punishment allowed under international law or prohibited? This discussion is over. It is clearly prohibited. And I think there is still a lot of misunderstandings in the discussion we have with both the government and civil society in Taiwan. There is another provision in Article 10, and that says, the penitentiary system shall comprise treatment of prisoners, the essential aim of which shall be their reformation and social rehabilitation. This means that the Covenant on Civil and Political Rights clearly spells out that the purpose of criminal justice is not retributive, but restorative. That means that every person, even if he or she committed a very serious crime, should still have the chance of rehabilitation and re-socialization into society. That is also why the proposal that was on the table of life imprisonment without parole violates Article 10. It's a clear violation because there is no more hope. If you are imprisoned for life and you have no hope whatsoever that you can get out of prison anymore, there cannot be any kind of rehabilitation. And of course, even worse, it's the death penalty. That's why when the international community established the ad hoc international criminal tribunals for the former Yugoslavia, then Rwanda, then Sierra Leone, and the International Criminal Court, there were long discussions whether there could be the death penalty. And it was very clearly decided that international criminal courts can never apply the death penalty. We are not anymore in 1945 with the Nuremberg tribunals or the Tokyo tribunals. We are in 2026, and the Rome Statute was adopted in 1998. And there we are talking really about the worst of the crimes that you can imagine, the crime of aggression, genocide, war crimes, and crimes against humanity. So even for those, and quite a number of those people have been sentenced, people who are responsible for the genocide of 800,000 people in Rwanda have been sentenced for genocide to a long prison term. The same for those who were responsible for the genocide in Srebrenica in Bosnia and Herzegovina. So international law is very, very clear on condemning the death penalty, even for the worst crimes. So that's why I think time has come, if Taiwan wishes to be seen, as my colleague Bill Shepard has said, as one of the countries that is among the most democratic and human rights-minded countries in Asia, and even around the world. As long as you keep the death penalty, you will not be in that list. That is a very, very serious issue. And if you would, and you cannot hide behind so-called opinion polls. First of all, probably these opinion polls are not conducted in a most scientific manner. But secondly, in most countries that abolished the death penalty, at the time when they did it, and I know it very well from my own country, Austria, if you make an opinion poll after a serious crime has just been committed and reported in the media, the big majority of the Austrian population would have said, we are in favor of the death penalty. But it was courageous politicians who felt it's our responsibility as the Minister of Justice or the Prime Minister that we feel we want to comply with international law, even if this is not very popular in our country. And they abolished it in my country in 1968. And today, it simply doesn't play any role anymore. It's accepted by the people, including by those who, at the time when it was abolished, felt it's better not to abolish it. But you will always have a small minority of people who still think it might be a good idea because they are believing in retributive justice. But as I said, retributive justice is not what international human rights law is telling us. So I'm a little bit disappointed, I should say, that after 13 years that we have been discussing this question, we have put all the legal arguments on the table. We have told you all the time that it's time you have to move towards abolition. The government of Taiwan invited us to assess the human rights situation in your country. And we have assessed the death penalty from the very beginning, and we feel that there's not much progress that has been achieved. And I think if I look into the more recent developments, there was at least a task force on the abolition of capital punishment, which shows that the government was accepting its responsibility to abolish the death penalty. Now I have the feeling this task force is more or less no longer existing, or at least not playing any significant role. And we are again in a situation where I feel that the situation becomes retrogressive. And I think this would be a very, very negative outcome of 4 times international review of the human rights situation in Taiwan. So I really strongly hope that we are not again in a situation where we get no clear commitments from your side that should there be a 5th review, that we then can say in the next 4 years you actually at least adopted a moratorium. And that is what an increasing number of member states of the United Nations General Assembly request all states to do. In particular, of course, states that on paper still have the death penalty. To adopt a moratorium, that's the first step. And then it might take some time until the legislative yuan would be in a position to actually abolish it from the criminal law of the country. But a moratorium can be done by the executive yuan. or by the president. And I think that is what I hope that during these few days that we are here in Taiwan and having an interactive dialogue with you, I would be happy if we would get this clear commitment from the government of Taiwan that you will impose a moratorium as a first and very important step towards real abolition of capital punishment. Thank you. Again, that was not a question, it was a statement. But of course, you're most welcome to respond or perhaps come up with a commitment. All right, I see no hands. Oh, there's one hand, yes. Thank you.
This is MOJ. Sorry, this is Judicial Yuan. In the 2024 Judgment 8, the Supreme Court has never finalized a death penalty. Before that, there were 36 death row inmates, and after Judgment 8, the Supreme Prosecutorial Office reviews such cases based on the conditions listed in Judgment 8, and the general prosecutor has already proposed extraordinary appeals for 5 of the defendants. And after Judgment 8, there are only 4 defendants which are sentenced to death penalty in district courts and high courts, but these sentences are not finalized yet, so they're still in the process of appealing. MOJ said that the executions are done very carefully or discreetly. You mentioned execution and death penalty and lack of progress, but I think we have made quite some progress.
Thank you. No, I definitely also respect very much the judgment of the Constitutional Court in that respect, which is applying very strict conditions. But of course, you are bound by the Constitution of Taiwan, whereas we apply international human rights law. So that is the difference, and it would probably be difficult for the judicial yuan to go beyond the Constitution and apply international law that prohibits the death penalty. But I see also that there is a certain positive trend, but I have now in the responses of the government already to our recommendations of the 3rd periodic report, and later in the responses to our list of issues, I detected a negative trend. I think the current responses are more kind of stronger defending the right of Taiwan to continue with the death penalty, whereas in earlier years we were moving already towards almost a consensus that it really should go towards full abolition, not only reduction. But thank you very much. Anything from my colleagues more on Article 6 and 7 relating to the death penalty? If not, then I would continue with Article 7, other issues. And unfortunately, it's a similar situation that, again, from the very beginning, we were recommending that on the one hand, it would be great if the Convention Against Torture and the optional protocol to the Convention Against Torture could be ratified similar to the many other core human rights treaties of the United Nations, and for reasons that are totally unclear to me, it was always the time passed, and then somehow in the interplay between the executive yuan and the legislative yuan, that it always had to be reintroduced again, and now I don't know where we actually stand, so that the conventions can be actually ratified and an implementation law could be adopted. But even irrespective of ratifying the Convention Against Torture, you have the absolute prohibition of torture in Article 7 of the Covenant on Civil and Political Rights. And in order to fight and to make sure that torture is not applied in Taiwan, there are two main methods to fight torture. The most effective one is to fight impunity for torture. How do you fight impunity? First, you have to define torture as a crime in the criminal law of Taiwan, as most countries in the world have done in the meantime. And that was one of our recommendations from the very beginning, and it was never implemented. You always said again, yes, we have all kind of other crimes, and if you take those crimes together, then we can say all together is amounting to torture. This is simply not true. Because it always requires, for instance, a physical injury and whatever. That is not the definition of torture. Torture is clearly defined in Article 1 of the Convention Against Torture. Whether you have ratified it or not is not important, but you need to make torture a crime. Only if you have done that, then you can answer our questions about statistics. We always ask the question, how many cases of torture did you have? And you cannot answer the question because you don't know what torture is. It's in the criminal law, it's not defined. And secondly, you cannot investigate the crime of torture if you don't have a crime of torture. And that's very important, that every suspicion or allegation of torture, if a person who says during the police interrogation or in a prison or in any other detention facility, I have been tortured, such an allegation must immediately be investigated by an independent and impartial body. But again, we don't know how many cases. There are many. We are reading about more than 500 complaints, and so many complaints relate to torture, but nobody has ever been brought to justice. Torture is one of the most serious crimes, one of the most serious human rights violations. But we have no idea from 4 times reviewing the situation in Taiwan, how serious the the situation of torture is in your country. If you are listening to certain non-governmental organizations, then you get a feeling that torture is still, I don't know, widespread, but at least it's occurring. And that's why it is very important that you take the respective measures, and that is, as I said, criminalizing torture and establishing a special body to investigate and prosecute, ideally a special prosecutor. Because usually, and that's an experience I have from many countries around the world, the police is not the best body to investigate police misconduct. So you need a separate body. And also the prosecutors, the ordinary prosecutors, they are always very often cooperating with the police because they need to cooperate in order to fight crime. But if they then should prosecute police officers or perhaps even prosecutors who were torturing, they are again investigating against their own fellow people. So that's why it is important to have an independent investigation and prosecution body if you really want to eradicate the crime of torture. The second main measure, kind of idea that has been brought up and applied very well in many, many countries around the world is preventive visits to all places of detention. The very fact that an independent body, and in Europe we have the European Committee for the Prevention of Torture that can visit and does visit all member states of the Council of Europe on a regular basis, and they can visit on an unannounced basis every detention facility, every facility where somebody is or can be deprived of liberty, not only police stations and prisons, psychiatric hospitals, migration detention centers, institutions for persons with disabilities, etc. Because if you are deprived of liberty, the danger and the risk of being subjected to torture is the highest. So if you have such a body, and the optional protocol to the Convention Against Torture obliges all states to establish what we call a national preventive mechanism, which is even more effective if it is independent. So a national body that on a regular basis and ad hoc can carry out unannounced visits to all places of detention. You can do that without ratifying OPCAT. And many states have done that in implementing OPCAT or outside of that. But you have an obligation under Article 7 of the Covenant on Civil and Political Rights to eradicate torture by all means, and those are the two most effective means. There are many other possibilities that you can apply, but these I would think are most important, and we have recommended that since 2013, and unfortunately that has not been implemented. And my question to you now, I put a question, why is that so difficult? If you are committed, and that's a difference, you are not committed to abolishing the death penalty, but you are committed, that's what you always said, to eradicate torture. So why have our recommendations not been implemented in relation to eradicating torture?
Thank you, Professor, for your question. I have summarized your question, including domesticating the Convention Against Torture, legislation, and some complaint mechanism. And I think this has a lot to do with our judicial and criminal justice system. So I will ask the MOJ to respond, and the Agency of Correction. First, the Central Police Agency, regarding the domestication of the CAT, in 2017, 2019, we submitted a draft to the legislature for review. However, if the bill was not reviewed and passed within the term of the legislature, the 4-year term, then we have to resubmit the draft again. That's why in 2024, we resubmitted the draft to the Executive Yuan for review. You mentioned that there should be an independent body for investigation. It is included in our draft. However, at that time, our laws and regulations still prevented us from setting an independent body beyond the judicial procedures. That is why we rely on the NHRC under the Control Yuan to perform independent investigations. So now even the CAT is not approved. We have been doing a lot of outreach and education training. Thank you. So the Department of Prosecutorial Affairs of the MOJ speaking about the bill, the Implementation Act for CAT. In 2023, we already commissioned the scholars to conduct studies to see the feasibility and necessity of adding cruelty as an independent offense in our criminal code. And we have received recommendations from the scholars. We, in 2025, organized several hearings and meetings to discuss how we can set an independent offense of torture in the criminal code. So we will follow the concluding observations, as well as all the public hearing conclusions, recommendations from the scholars to make necessary revisions and amendments. Thank you. The Agency of Correction under the MOJ speaking. Good afternoon. Complaints in the prisons, basically for inmates or detainees, they may file for they may file complaints seeking remedies, and we will look into their complaints, whether or not such complaints go on to criminal justice. It depends. So once criminal investigation procedure is initiated, then that means the inmates or detainees directly file criminal lawsuits against the staff members of our correctional institutions, or if we think the staff may be criminally responsible for certain incidents, yes, we will also initiate the criminal procedures. For example, last year, we took the initiative to identify certain criminal issues in the correctional facilities. There are 6 cases of this kind. There's also one case where the detainee or inmate filed a complaint against our staff members. So I believe for inmates or detainees, the process is very transparent and open.
I cite from your report, and that's the 4th report on the 2 covenants, page 23. From 2020 to 2024, a total of 5,847 complaints were filed by inmates. That's quite a lot. What happened with it? When we look further down, we say, among the cases in which investigation reports were concluded by the control yuan, 15 cases involved the right to freedom from torture. So 15 clearly torture cases. And then it says the control yuan demanded corrections in 7 cases. I don't know what that really means, and filed a censure in 1 case. And then we have statistics, and then we have also some of those cases. Torture was inflicted upon inmates by management personnel at Taipei prison under the Agency of Corrections. I don't see that any person was brought to justice. Again, torture is not a small administrative offense or a disciplinary offense. Torture is one of the most serious crimes that, according to the United Nations Convention Against Torture, should be punished with appropriate sentences. These are long-term prison sentences. Can you tell me how many of those persons who alleged torture and were even the investigation said torture was inflicted upon inmates by the management personnel of Taipei prison, why those persons responsible have not been brought to criminal justice?
法务部矫正署。
This is Agency of Correction from MOJ. You mentioned there were more than 5,000 complaints. I have to make it clear that these complaints are about administrative procedures. These complaints were not about violence or torture inflicted upon the inmates, because currently inmates in the correctional institutions have freedom of speech, freedom of communication. They can write, they can petition. So the only thing they are being deprived is their liberty. They have the freedoms of speech and thoughts. They have their entitled rights, and they can ask for the rights. So I think you mentioned that there are more than 5,000 complaints. In our views, that's a very common number because they are about administrative procedures. And sometimes the inmates do not follow the orders in the prisons. So we deduct some points from them. They may fight among each other. Usually they are punished by having some points deducted. And point deducted are going to impact their parole approval. Sometimes they want to be transferred from prison A to prison B, but they cannot just choose where they want to go. So they file complaints about these things. Other than that, we have low or minimum security prisons, meaning that that's a intermediate treatment. So when inmates have paroles, they can move to that low security prisons. But it's conditional. It's not that all the applications will be approved. And all of these are the reasons of their complaints. The complaints are not really about they are being treated cruelly or inhumanly. Of course, sometimes correctional officers are emotional. If they misbehave or have poor management, we do not allow it. We send them to the treatment that they deserve. If they should go to criminal procedures, they are sent for criminal justice. The recent criminal case was in 2019 in a Kaohsiung prison. 2 management personnel didn't do their job in managing. So inmates fought among each other, and someone ended up dead, and an inmate dead. So these 2 management personnel were sentenced to 8-year and 5-year imprisonment. We are, of course, unwilling to see such unfortunate happening, but occasionally the personnel are not able to fulfill their responsibility or they're not careful enough. But we are willing to openly address these cases. And you also mentioned the Taipei prison case. I think that case was in 2014, and the inmate had mental issues. So when the personnel was supposed to protect that inmates, they neglected something. They didn't have close monitoring, and therefore there was a death in the end. And this personnel was sent for treatment, but it was not that the personnel directly inflict torture on these inmates and leading to his or her death. So after judicial investigation, this case was not prosecuted, but he had administrative responsibilities, and therefore he had administrative punishment. Thank you.
Afraid we are speaking of 2 different events. I am referring to your report, 4th report on the ICCPR and ICCPR, pages in the English version 24 and 25. And there is a summary of control yuan investigations, corrections, and impeachment involving freedom from torture cases. I'm not talking about death in prison, torture cases. And it was found, I guess, because that is what the control yuan said, torture was inflicted upon inmates by management personnel at Taipei prison. That was not in 2014, it was in 2023. Or in Dunbin High School experienced an incident involving the maltreatment of 5 students in residence. So isolation measures under extremely poor sanitary conditions, etc. So these are cases that are freedom from torture cases, and the kind of final outcome was disciplinary, also a request to review disciplinary measures. We don't even know whether there were disciplinary measures, or that somebody was reprimanded, or the superintendent was censored, reprimanded, etc. But as I said, there were never any case of a criminal investigation or criminal punishment. And I think that is, so I can only conclude from this that torture is considered in Taiwan as a very, very minor offense that might lead to a disciplinary punishment or reprimanding, but is not seen as a criminal offense. And again, I repeat my question, why has that not been taken more seriously?
矫正署针对刚刚台北监狱那个部分有没有做回应一下？
For the 2023 case, anything to add? It was not a case of torture. The judicial institution did investigation, but that was a case of an inmate with mental disease. So the result was non-prosecution. The 2023 case, there was death. So when there was death, we sent the case to judicial institution for investigation. As for the inmate with mental illness, he induced chaos, and the personnel put a helmet on this and the inmate and moved this person to a different corner for protection. Maybe the helmet was on his head for too long, and the personnel didn't pay attention to these inmates, and that's why the inmate died. It was transferred to the judicial proceedings for investigation, and the result was non-prosecution. So there was negligence, but it was not direct infliction of torture or harm on the inmates. So if there's censure from the control yuan, I think whenever punishment is deserved, we definitely send it for administrative or judicial procedures. We will continue to review and improve. As for juvenile and students, they are more emotional. They have impulses. They may fight among each other or fight against the management personnel. They do not want to obey some laws. But regardless, education and rehabilitation are always the priorities. So there wouldn't be any irrational torture imposed on them. I think that's a very basic professional literacy that we have.
All right. I think we should move to Article 8. Thank you.
Thank you. Well, for Article 8, dealing with slavery, the slave trade, and servitude, we asked for clarifications and information in two questions on the list of issues. I don't have anything to beyond that. I'm satisfied with the explanations, and I have no points to make on that. And no questions to ask.
Is there any additional information that you would like to provide on Article 8? Then we come to Article 9, deprivation of liberty. And I have a more general question relating to children deprived of liberty. Under the United Nations Convention on the Rights of the Child, every person up to the age of 18 is regarded as child. You have a different terminology. You say children are only up to the age of 12, and then between 12 and 18 you speak of juveniles or adolescents, but then you have an own category of 12 to 14, because the minimum age of criminal responsibility is only reached at the age of 14. And for children in conflict with the law, there are different possibilities of depriving them of liberty. On the one hand, there are the correctional schools, and if I understand correctly, they are for those who are sentenced. But are they only for juveniles between 14 and 18, or what's about those between 12 and 14? And then you have the juvenile detention centers, which seem to be for pre-trial detention. And recently, the Referral Education Act was adopted, where children with deviant behavior can be referred to education placement. So that seems to be another institution where children can be deprived of liberty. Can you please explain and perhaps also provide us with statistical data? So how many children, and in particular in which age groups, are currently or have been in 25 in correctional schools, juvenile detention centers, and in these education placement centers? Please. Please.
So maybe we can ask the Judicial Yuan, the Ministry of Health and Welfare, and the Agency of Correction to respond. The Judicial Yuan, regarding your question, we have set distinctions among different age groups of children and juveniles according to the Juvenile Justice Act. Basically, we refer to those aged between 12 and under 18. So for children or juvenile who breach the criminal code, then in the spirit of the CRC, the protective approach will take precedence. As for those aged between 12 and 14, if they breach the criminal code, then the Juvenile Justice Act applies. As for those aged between 14 and 18 or under 18, if they breach law, they may be criminally responsible because, as you mentioned, criminal responsibility will be borne by those who are aged 14 and above. So, but before criminal responsibility begins, the juvenile court judge will have to make a decision, that is, whether this is a case involving major crime, involving 5-year imprisonment, or which approach is better to deal with this juvenile delinquent. Also, for deprivation of personal liberty and detention centers, etc. In fact, the juvenile detention centers may restrict juveniles' liberty, but it is not a criminal detention. Basically, for those aged between 12 and under 18, if they breach law, we think it is more important that they have some protection. Perhaps they are homeless, then we will place them in the juvenile detention center. It is not the same as criminal detention. So children in juvenile detention centers still get educated. If they are students, they get taught, and they have very regular schedules like most young people, physical activities, studies. If they go to educational placement institutions, basically, if the child is involved in some law-breaking behavior, it is not appropriate for them to return to their original schools. Then we may place them in a halfway school where they can stay for 1 month, and they can stay for another month maximum. This is a temporary arrangement, and this arrangement aims to help the child to eventually return to their original schools. As for correctional schools for juveniles, again, there are two types. One is juvenile prison, the other is juvenile correctional institution, but we all refer to them as correctional schools. It's, again, a form of protection for juveniles. For juvenile prisons, basically, this is the place where the criminally responsible juveniles go to. As for the disaggregated data, I think the Agency of Correction can provide such data. The Agency of Correction speaking. You ask about juvenile detention centers and the 4 correctional schools. As of the end of March this year, for juvenile detention centers, 293 juveniles. As for the 4 correctional schools, in March 2026, 960 juveniles are in the 4 correctional schools. The Judicial Yuan speaking, you ask about children in juvenile placement institutions between 2020 and 2024. 103 in 2020, 80 in 2021, 74 in 2022, 52 in 2020, 54 in 2023, 64 in 2024. Again, these placement institutions are different from detention centers where personal liberty may be deprived. Again, they can go to school, they can go to work. Placement institutions are really a substitute for their family temporarily. The Ministry of Health and Welfare, anything to add? The Ministry of Health and Welfare, in response to your question about juvenile placement institutions, the data we will provide you later after the session.
I was also just reminded by my colleague Dunya that we will take that also up tomorrow under Article 24 of the Covenant. And perhaps it's possible to provide this data until tomorrow. For under Article 9, it is important to what extent these children are really deprived of liberty. That means detained. They cannot leave at their free will. And to what extent the relevant authorities take into account also the Convention on the Rights of the Child. Article 37b is very clear in saying that in case of children, and that means up to the age of 18, deprivation of liberty should only be a measure of last resort, so really when there is no alternative, and if absolutely necessary for the shortest appropriate period of time. I think these are very high standards that the Convention on the Rights of the Child applies. I have still a totally different question that also overlaps a little bit with Article 25, you said, and I would have to find the relevant page, that it's on the fourth report, 121. Paragraph 310. As of 2024, there were 57,699 people accommodated in correctional institutions who had the right to vote but were unable to do so. This is more or less the total prison population. So that's quite stunning because, as we heard before, deprivation of liberty means that your right to personal liberty, you are deprived of your right to personal liberty, but not of all the other rights, whether it's freedom of speech or freedom of religion or the right to vote. And there is clear jurisprudence on this. And Article 25 of the Covenant speaks not only of the right, but the opportunity to exercise your vote. So it means there's a positive obligation of the state to provide prisoners, whether they are in pretrial detention or already sentenced to prison, with some kind of possibility, whether it's having special voting stations in the prisons or absentee voting, electronic voting. There are many different ways that you can do it, but simply saying they were unable to do so looks for me as a clear violation of prisoners' rights. And I see Chauffeur O'Leary.
Cover this tomorrow under Article 25, this aspect.
Yes, it's a combination, of course, yeah. But perhaps there's a first answer, and then perhaps there's time to think about that until we deal with that tomorrow. It's any other questions from my colleagues or any comments or questions from you? Because we have still more than an hour left, and I am, apart from I've only on Article 10, I've seen that there were certain improvements relating to the overcrowding of prisons, but still the total number of prisoners in Taiwan is more or less equal to the places that are available in correctional institutions in Taiwan, which means certainly that since there are differences in between different prisons, that there is still overcrowding. So what are further measures that the government plans in order to reduce overcrowding, which of course also means that the conditions in these detention facilities are not necessarily in conformity with the highest human rights standards.
请矫正署
Agency of Correction. Thank you for your question. Indeed, by yesterday, more than 63,000 inmates are in such facilities. It is a status of overcapacity. This is because the executive yuan now has stronger anti-fraud enforcement, because fraud is harming social order in a very serious manner. And that's why there's a sudden increase of fraud inmates. Targeting this reality, we are managing and we are expanding the construction of the correctional institutions. Starting from this March, the low security prisons in Bade and Sanhe detention centers have increased their capacity. We will continue to mitigate such overcrowding. I think correctional institutions work to improve the social order, from detention to case management to trials. We have an overall perspective and way of doing things, and then make adjustments. If we want to address the overcrowding, we are seeing that there are more crimes and more population in northern Taiwan. So we may move some of the inmates to the south in order to balance the overcrowding issue. Other than that, we also adjust the parole procedure so that inmates who are ready to be reintegrated can be sent for paroles as early as possible and return to the society. So we have two pillars, the front end and the back end, so that overcrowding can be addressed in a humane way while still providing a good social safety net in our society. Thank you.
Thank you. I've still another question. According to Prison Watch, there are external inspection teams in prisons and detention centers. They are responsible for the oversight of correctional institutions. So since you have not ratified OPCAT, there is no national preventive mechanism, but there are these external inspection teams, and it says these teams are appointed for 2-year terms and conduct a maximum of 1 quarterly visit, each lasting approximately 2 hours, followed by an inspection report. So my question is, first of all, is it true what Prison Watch is stating here? Secondly, if it is true, why are these visits only taking place once per quarter and only for 2 hours? And who is appointing the members of the inspection teams? How many people are in these inspection teams? Are they independent or are they employed? Just to get a little bit more information about that, and then they publish or make or submit an inspection report. Could we have more information about these inspection reports? Do they raise serious issues about the conditions of detention, or perhaps maltreatment of prisoners? Yeah, whatever you can provide information we would be very grateful.
各位审查委员，大家好。
This is the Agency of Correction. As for external inspection team, in 2020, Prison Act and Detention Act were amended. So that's when external inspection teams started to work. There are guidelines to authorize such teams. External inspection teams can go to such facilities to perform inspection. And you ask whether it's only done quarterly and only 2 hours every time. It's not a limitation, actually. The guideline state in Article 7 of the guideline or enforcement rule says that there should be an inspection meeting every quarter, and they should submit inspection reports. But actually, they can go to correctional institutions as needed. So at any time, an example, all the correctional institutions have a specific mailbox for external inspection team. If inmates want to submit complaints, but not to or not through the correctional institutions, they can write through this mailbox to the external inspection teams. When there are complaints in such inbox, this is going to initiate the inspection, and meaning that the times of the meeting, the times of the visit will increase. So NGO mention sometimes and numbers, but it's not exactly the same in the realities. And we also respect these external inspection teams who come to correctional institutions. From 2020 to now, I think we have 4 terms of the teams already. You ask about who are the members of the inspection team, from which areas are they from? They cover many different areas: law or social work, social affairs, medicine, education, and per the enforcement rules, we have a database for potential inspectors. And by this month, I think there are 615 possible candidates, and 76 are recommended by public agencies. From schools, they can also recommend. I think there are more than 400 recommended by schools. Self-nominated, there are 105. So these external inspection team have their members from outside of the prison. So through these teams and inspection, we want to make the correctional institutions more transparent. They can bring us recommendations so that we can improve our administrative measures. Thank you.
No, thank you very much. That's very helpful. Who is appointing the members? And are there inspections unannounced, or they tell you before when they come to which prison?
Again, from the Agency of Correction. So who assigns the members? Currently at our agency, we have a selection team. The function of this selection team is to select the members of all kinds of inspection teams. And the members of that selection teams actually come from different areas. They are experts and scholars. And this week, we are going to convene a selection meeting for the 4th term of the external inspection team. There will be discussions about unannounced visits to the sites. Well, external inspection requires some engagement with the prisons or the institutions. So they will have to communicate before the visit happens. As of now, there aren't unannounced visits, but correctional facilities may receive some unannounced visits. The integrity agency from the MOJ may perform unannounced visits. There could be some project or special inspection project from those departments. Maybe what you want to know is, well, if the prisons already know when the team is coming, they will prepare. Well, from our perspective, we also perform regional visits. We go to different institutions, and the Department of Integrity will also make unannounced visits. Then, plus we have the external inspection team. they have different backgrounds. They are different experts and scholars. So I think different kinds of visit do have their different functions.
All right. Any other questions that you would like to bring up under these 5 articles? No tennis today.
Oh, we've done 10. Okay. No.
Still, any final comments or questions from your side? Yes, please.
Chair and distinguished members of the review committee, on behalf of the NHRC, I am Ye Dahua, Commissioner. Regarding your question about children and the juveniles' treatment in correctional facilities and detention centers, and I myself, as a member of the Control Yuan, did some investigations into the situation in those facilities. In addition, the NHRC in 2021 also proposed a pilot MPM project, and the MPM pilot project aimed to look at the situation of children and juveniles in the juvenile detention centers and the 4 correctional schools. We also have a report for that program. We can provide you the report later. In the report, we invoked the Mandela principle as well as the Havana principle and the Riyadh principle and the Beijing principle when we performed the visits. So I have a question or a reminder, that is, now in Taiwan, children and juveniles in correctional facilities face 2 challenges. One is the hardware facilities. Most of such facilities have been in existence for decades. They were built during the authoritarian regime period. So whether we are talking about correctional educational institutions or juvenile detention centers, you will see the conditions there are worse than prisons for adults. And based on the Control Yuan's visit, we also noted that such poor hardware facilities has a lot to do with overcapacity. So in such institutions, usually privacy is minimal, and basically the overall environment is pretty poor. 6 to 7 teenage boys are placed within a very small space. As a result, conflicts arise, including sexual bullying or violent incidents. So based on our investigations, because we used to have the juvenile correctional system, which was different from the correctional schools and juvenile detention centers we have today, yet the system still has the legacy of a hardline management style among the management staff. And they usually allow the detained juveniles to manage among themselves. So usually this may nurture a bully among a small group of juveniles accommodated in the same room or area. As a result, inappropriate teaching or corporate punishment or even human rights violations, sexual abuse, bullying became rampant. So after the investigation, we reprimanded the head of that correctional school we visited, because that principal used to run an adult prison. So he was not capable of running a juvenile correctional schools. A lot of issues arose as a result. So we reprimanded the principal of that correctional school, and he was removed away from that school. We want to emphasize that the head of a correctional school must have the capacity and literacy to know how to help young juveniles to rehabilitate. And you ask about the justice for these victims. And I think the Control Yuan did conduct investigation and taken action to penalize people who are supposed to be responsible for the misconduct. On the other hand, the poor hardware facilities, we noticed that over the weekend, especially some correctional schools in central part of Taiwan, because there's a short of hand, over the weekend, these detained juveniles had to stay in their rooms. They were not allowed to leave the correctional schools for leisure activities, thus depriving their right to take part in public affairs. And in our NPM pilot project report, we did highlight this problem and made recommendations for improvement. It is a pity that the MOJ did not respond to our recommendations proactively. Of course, now the 4 correctional schools have transitioned, evolving into more like halfway schools. Now, the executive branch has been pushing for the juvenile correction regulations. However, it is still a draft, and it has not been reviewed completely. It's still being discussed inside the executive yuan. So I think there's a lot we can do more to improve the juvenile justice system, including the correctional system. The quality of the correctional education, the quality of the facilities, all fail to meet the Havana principle.
Thank you very much for this additional information, which confirms situation that we have in many countries around the world. When I conducted this global study on children deprived of liberty worldwide, we realized that that time it was more than 7 million children worldwide are deprived of liberty. and that's clearly in violation of Article 37b of the Convention on the Rights of the Child, because that cannot be a measure of last resort. And many of them are in the juvenile justice system, but others are also in institutions. I mean, the main recommendation is definitely that we should move from deprivation of liberty as a punishment for children, juveniles. We should move them from the criminal justice system to the social welfare system, and provide, instead of correctional schools or other type of boarding schools, etc., which are the conditions are often worse than in classical juvenile detention centers, prisons. And they are as much deprived of liberty as they are in the formal detention centers. And if by means of diversion and other measures, these children can be moved as much as possible to the child welfare, and that means to family-type accommodation rather than in big institutions, that would be the most appropriate way of dealing with children in general. That might also be children who are orphans or coming from families, drug-using families, etc., who are separated from their parents, but also children that are engaged in what often is called antisocial behavior or even criminal behavior, that should be much more dealt with by a well-functioning and well-resourced social welfare system rather than by the judicial system. But that's a long-term process of de-institutionalization. And in many states, we had very, very good kind of results on the basis of this global study and United Nations de-institutionalization policies. But thanks very much for this information, and perhaps again, as Dunya said, that might come up again tomorrow, the whole way of dealing with children in Taiwan. So perhaps your contribution might give rise to some thoughts how we deal with children in conflict with the law, also in Taiwan. And perhaps tomorrow, Dunya, we could also raise, I still don't understand what the 12-year means. Why is there a distinction between 12 and 14? Because if 14 is the minimum age of criminal responsibility, then juvenile courts should have nothing to do with 12-year-olds. But I don't want to continue this discussion because we will take it up tomorrow, but perhaps we could have an answer why 12-year-olds are treated already in the criminal justice system, although they are not criminally liable under Taiwanese law. Any other comments or questions? Yes, please.
Good afternoon. The Agency of Correction speaking. In response to your question and comments about correctional schools and the quality and conditions of these schools, in fact, since 2021, we have been making improvements. First of all, in terms of hardware facilities, yes, right now in all correctional schools, all students have bunker beds, sleep on bunker beds, including the recently completed correctional school, Chenzhen middle school. They all provide bunker beds for their detainees. So that's some improvement for the conditions in the facilities. As for teaching space, since 2021, we also leverage the funding from the Compulsory Education Administration of the MOE and our agency's own funding to install wireless connection, improving teaching facilities. As for other mentoring services, since 2021, 3 correctional schools have been working with local well-known banks to improve their hardware facilities, including Chenzhen, Dunping, and Mingyang middle schools, all have better space for counseling services. After the renovation, this counseling space will be just like any other counseling offices in the society. I think they will probably even have better quality. As for the teaching personnel, in the past 4 years, for the 4 schools, the teacher and student ratio is 1 to 26, and the teacher, well, for special education teacher students, the ratio is 1 to 12, and student and psychologist or therapy to student ratio is 1 to 11, and the social worker ratio versus the student is 1 to 51. As for their weekend schedule, in fact, during holidays, students have the opportunities to go to the outdoor area for exercises. And this is what is happening in the correctional schools. I also want to supplement NHRC commissioners mentioned bullying on campus. After correctional schools are reformed, we want to ensure that the teenagers or children are covered by the basic education law. So last year in June, we had designed the measures for bullying and treatment in correctional schools. It is very clear that the teachers should perform their roles, and if it is a case of bullying between teacher-students or student-to-students, there are different measures and mechanisms.
Yes, sorry.
As for our specific measures, there are clearly guarantees and specific measures. For campus bullying, on gender equality, we have been working on those front in recent years. In the 4th correctional schools, we have sent 24 staff to receive gender equality events handling approaches, and 8 of them have finished advanced training, and they are included in the database of gender issue handling. And we will continue such trainings in the future. Thank you.
Thank you very much. Any final comments, answers, questions?
And I will respond to MOJ's early answers. I think some of the responses are as such because they make improvement after the control unit investigation. Indeed, correctional schools have made gradual improvements, but there are 8 juvenile detention centers still. The Judicial Yuan has mentioned that it seems the right to education at the juvenile detention center is guaranteed, but the NHRC has done investigation. It seems that it's not true because some of the juveniles are in such centers for a very short period of time. So they may not be able to receive education according to the teaching curriculum. And other control unit members have researched on the right to education in such centers. It seems that professional teachers are lacking in the detention centers. The teaching materials do not meet the needs of the students in the juvenile detention centers. So many of the students are not able to catch up with the materials or the lessons. Another issue at the juvenile detention center is that the teenagers some of them are quite young in the centers. And they are bullied by older teenagers. Some are really serious sexual harassment or sexual abuse. And there's also a case when a very young person was sent to the juvenile detention center for more than 200 days. The juvenile detention center is only there for short-term placements, but in order to work with the judge's schedule, that teenager stayed in the juvenile detention center for such a long time. And that case was actually investigated by the control yuan. So I think MOJ, of course, has to attach more attention to juvenile detention center rather than the correctional schools. Another point of mine is that MOJ wants to reform the prisons. And in fact, a lot of investment has been made to improve the hardware in adult prisons. 2.8 billion NT dollars is invested in the smart prison. But it seems that the funding for juvenile detention center or other juvenile institutions is lacking. It's extremely limited, and that's why there are so many problems coming out from management. And that's why I say to you that please pay more attention to juvenile detention centers and correctional schools because they are not in line with the UN standards for teenagers who are deprived of liberty.
Thank you very much. All right, if there are no more, yes, please.
Thank you. Commissioner Ye from NHRC has provided some comments, and I would like to respond briefly. Juvenile detention center and correctional schools are 2 different forms of institutions. Juvenile detention center, well, just like the adults, they are like kind of like adults defendants. They have illegal behavior, and the judges believe that they should be temporarily placed. Normally, they are in the detention center for 2 weeks or as long or 1 month max, or two months max. So you mentioned 200 days. I don't have the impression of such case. It must be a very rare case. Maybe the decision was made in relation to a special investigation by the judge, because usually they only stay in the detention center for 2 weeks or a month, not 200 days. In such cases, it's very hard to make such centers into a school because they are there for a very short period of time. Usually, we have teachers coming out from other schools to come and to give lessons. Because what really matters is the afterward displacement of the afterward placement of these teenagers is more important instead of what education is provided in the detention center, because all the juvenile offenders have different levels of education. So how do you provide universal education there? I think, practically speaking, it was very difficult. So I think we work with the juvenile courts, the juvenile investigators, the juvenile probation officers when they think it is necessary to place the juvenile offenders. They are sent to the juvenile detention center. And there was a point saying that we pay less attention to the hardware or the environment in correctional schools. I think there is misunderstanding because for juvenile the juvenile inmates or offenders, we pay attention to counseling and education. For adult inmates, we pay attention to safety and discipline. So you see the hardware is improved more significantly in prison for adults. In correctional schools, we attach more importance to counseling, to education, to the integration of correctional schools and the families. And so there are different focus. So the treatment for juvenile offenders or adult offenders are different. So it's not that. So one cannot say that we don't care about the life of these teenagers, and instead we care a lot. We hope that they will be reintegrated to return to their family, to continue education and have a job. That's what we care the most. Thank you.
Thank you. Right. That brings us to the end, I think, of this afternoon session. Thank you very much for all the different explanations that you have given, and also for some kind of disputes between the National Human Rights Commission and the Office of Corrections. That makes it a little bit more lively. We look forward to see you tomorrow morning when we continue with Articles 12 and the following of the Covenant on Civil and Political Rights in this constellation. We have now about an hour. No, I have to see when we meet the non-governmental organizations. That is 17:20, so it's almost an hour, yes. Thank you. Have a nice evening.
This is the end of this session. The next session with the government will start at 8:30 tomorrow. If you want to make submissions per the request or on your own, please email them by 6 p.m. to the Secretariat. Thank you for your participation.
次国家报告国际审查会议与非政府组织之会议第3场次会议开始。
Session 3, meeting with non-governmental organizations. The chair will determine the order of utterance. Please make sure you speak at a reasonable speed to facilitate interpretation. Please also identify your affiliation after your utterance. Turn off the mic, please. Thank you.
Thank you. Welcome again. I hope that you had a chance to listen to our exchange of views on Articles 6 to 11 of the Covenant on Civil and Political Rights. And I would like to open this session by just asking for your feedback. Anything that you feel was important, interesting, etc. Please, you have the floor.
谢谢. Thank you. So, Taiwan Alliance to End the Death Penalty. Now is the second day of the review. The issue of death penalty is really important. I know that maybe we all hold different views about the issue, but I want to emphasize that to support the abolition is not to oppose the interest and the rights of the victims, nor do we want Taiwan to become a worse place. Rather, just like everyone else, we want Taiwan to be a safe society. We don't want there to be more victims. It's because of our love and the responsibility towards Taiwan that we support the abolition. This may sound counterintuitive. Actually, we have given it a lot of thought. In 2013, we already commissioned the Academia Sinica to conduct a opinion poll, and Professor Roger Hu was also involved. As you all pointed out in the previous session, the results are the same. And the MOJ had to conduct opinion poll as part of the National Action Plan on Human Rights. We recommended then that they can work with Professor Carol Iho from Oxford University and followed the methodology used by the Academia Sinica in the year 2013. Unfortunately, they didn't take our advice. They invented their own methodology. And as we heard from the MOJ representative talking about the opinion poll results, we did not know the result until today. So far, we have not read the full result of that opinion poll conducted by the MOJ. In addition, we spent 2 years interviewing 37 death row inmates and 40 inmates on lifelong imprisonment because we would like to know what serious crime they had committed, what they had gone through, what the situation was like in the prison. And this report was completed last year, and I am going to show you the copy of the report later. There's no way we can live in a crime-free society. Crime is always going to be present. That's why we want to conduct very disciplined and stringent field study to help government and the public to understand the structural factors contributing to crime. That's why the title of the report is The Weight of Crime. We want to have adequate punishment which can change people for the better. If we have a biased punishments, it may result in infringement of human rights. So if we can try to do this, trying to communicate with the society, the MOJ, the NHRC can definitely do likewise. So another issue is about the Constitutional Court judgment number 8 of 2024. We are disappointed at that judgment, but we have to accept that. That's the status quo. There are 35 death row inmates who have been in prison for over 23 years. I am aware of the heinous crime they committed years ago. It's difficult to excuse them, to forgive them, but from the legal standard or human rights perspective, these cases involved very seriously flawed procedures. They are not supposed to be sentenced to death penalty. They deserve to be punished severely, but not capital punishment. However, so far, it's been almost 2 years since the judgment number 8. The Prosecutor General has filed extraordinary appeal on behalf of 5 of the death row inmates. The other 31 are still desperately waiting. And one of the 38 death ring rows that applied for extraordinary appeal passed away due to disease. So far, we still have 35 death row inmates. I think this shows that our executive system has been slacking off. The prosecutorial system has not adhered to the stringent requirement set out by the Constitutional Court. The government actually leads in the unconstitutional work. And I disagree with what the MOJ said in the previous session, that all the executions have been carried out with most stringent caution. In fact, since the execution in January last year, the Minister of Justice simply disregarded the Constitutional Court judgment, and they even amended the execution rules to facilitate execution down the road. So I think the biggest problem regarding the issue of death penalty is now things tend to be rather murky about the death penalty after the judgment number 8.
Please, 1, 2, 3.
Chair, distinguished members of the committee, good afternoon. I would like to make the following 4 points. First of all, the MOJ implemented the amendment to the execution rules in April 2025. I don't think that amendment safeguards human rights. Rather, the government is taking advantage of the existing administrative rules to override judicial final decisions. And that means the legal stability is being undermined because of the laziness of the executive branch. We also face the very arrogant judicial branch. Basically, one vote to veto the decision. That can happen anytime.
Other than that, the judge abused their power in interpreting the most heinous crime or the most serious crime, and they use the possibility of being reintegrated back to society as a mask, which is done through psychiatric assessments. It is used as a way to protect the offendant. This is not science. This is humiliating the rights of the victims. I also want to touch upon why there is such an imbalanced policy in Taiwan, because in human rights consultations, they fall into the statistical trap when the government continue to listen to specific groups and deliberately excluding the participation of the family members of the victim. This is structural bias. This is obvious inequality. Excluding the voice of the victim is the secondary harm or damage done to us. We call to the committee members to investigate whether there were these kind of situations in the human rights reports and to urge the government to make improvement afterwards. Chairperson of the committee members, we are seeing administrative delay and judicial arrogance and false science. This is a unlimited loop or a cycle. We're like the Sisyphus who's pushing the rock upward to the mountain in the Greek mythology. We're facing continuous despair all the time. We're waiting for the verdict all the time. No matter how much compensation or therapy is given, they're not able to repair what we've lost. Lastly, Hannah Allen said before that the duty of the justice is not to understand or to educate the criminals, but to maintain the order of the world. I've concluded my remarks. Thank you, Chairperson. Thank you, all the committee members. Thank you for giving us the opportunity to give our voice. Thank you.
Thank you very much. Please.
委员好。
I'm from Judicial Reform Foundation. I want to speak about torture. As you mentioned in the previous session, currently we do not have the offense of torture, and therefore it's very difficult to have data. So I want to explain this issue in Taiwan through some judgment or stories. About a year ago, there was a judgment. That was the first instance. Yeah, it hasn't been finalized yet, but I think that's a good example because it happened about 2 years ago. So a police officer was chasing after a thief stealing a scooter. And the offender said he didn't do it. So the police officer was very angry and used the baton to hit the belly of this suspect, and then the spleen of this thief broke, and then he died because the suspect was able to walk on himself. He asked the police officer to send him to the hospital, but the police officer dragged this suspect to the police station. So he died, and the verdict this year sent the police officers to 6-year sentence. And in fact, the actually, he can be sent for a 7-year imprisonment, but it was reduced because the court says that the spleen of these victim was problematic already, and then the police officers has a lot of pressure to crack a case, so he lost his temper. So it seems that there isn't zero tolerance for our torture, no matter among our officers or the judge. I think this is a joke, and our foundation and many other NGOs think it is necessary to pass a CAT and an offense of the torture. We don't have data, as you said, but I would like to. So that's why I used this verdict that happened a month ago to explain what difficulties we're facing in Taiwan in terms of torture here. Thank you.
You have the floor.
This is TAPCPR, Taiwan Alliance to Promote Civil Partnership Rights. So in the previous session, it was discussed that torture was not or is not included in Taiwan's law just yet. And in this morning, you spoke about the rights of the transgender community. Currently, if transgender want to change their legal marker, it requires the removal of their reproductive organs and 2 certificates issued by psychiatrists. I think that's torture for transgender community because their personal willingness is violated. The law forces them to perform surgeries that they are not supposed to go through just in order to change their legal marker. And these affect their daily work, life, education, employment. These also affect whether they will be discriminated against in, say, military or in a workplace. So in Taiwan, there are some administrative verdict examples states that some transgender people are able to change the marker without the surgeries because they have the support from the group of lawyers. So there are cases already, but the administrative agencies, like the household agencies, it doesn't follow such cases. So they don't just go ahead and allow transgender people to change that legal marker. As you can see in this venue, all the toilets are single gender. There's no unisex toilet. In workplaces, in schools in Taiwan, this is very common. So since transgender people's sex or gender marker on the identification is different from their own identification, they face so many challenges in their daily lives. Some of them face economic challenges as well. This is a very common issue. So we call upon to you to provide recommendations to the Taiwanese government because there is a lack of measures and the administrative agencies are not following some legal cases, especially on the requirements of mandatory surgeries. We want to prevent transgender people from being harmed by the system. Lastly, the Taiwanese government is studying to ask the transgender people to still serve in the military before they finish the sex reaffirming surgeries. This is a huge source of fear for transgenders because they have to go to a male-dominated military camp to be trained, to use the bathroom, and to live with everyone else. This is a lot of risk. So the Taiwanese government is studying this measure. It's not officially in place yet, but we ask you to provide better recommendation to the Taiwanese government.
Very much. I have 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2,
这个事情监督联黄一碧。那首先，我希望能够先回。
I'm Ibi Huang from Covenant Watch. I want to bring you back to two cases you mentioned back in 2013. Mr. Su Jianhe and Mr. Qiu Hesun, these are two death penalty cases. After the first review, Su received constitutional verdict, which was a non-guilty verdict. But the three defendants in Su's case are facing the civil litigation asking for damage compensation. So even though the case was from 30 years ago, the evidence which arises from torture is still used by the civil courts. So we want all the experts in your CORs this year to restate that the evidence from torture must not be used in criminal proceedings. It must not be used in civil litigations either. That is to say, any evidence from torture should not be admitted into litigations. So that defendants who are exempt from criminal litigations don't have to face civil compensation claims either. Cho's case, on the other hand, is a wrongfully convicted case. He was arrested in 1988. He has been in prison for 38 years. In CORs in 2013, experts stated that if there's no exemption, and at least there should be opportunity to mitigate the sentence. But this person has been in prison for 38 years. He is on the verge of a mental breakdown. So we hope that in your COR this year, please re-examine Cho's case and Su's case, and to call for a special pardon from the government for Cho. As for the external inspection team, I also want to point out that there are 51 prisons in Taiwan, and all of them have their own external inspection teams. A big problem for these teams is that, well, even though MOJ say that they have a selection committee to select the members of the inspection team, but the long list of the candidates, in fact, is compiled by the prisons which are subject to the inspection. So the agencies which are going to be monitored get to choose who is going to monitor. This is ridiculous. And Manfred Novak asked whether such teams can perform unannounced visits. Actually, external inspection teams don't have opportunity to perform their duties independently, from whether or not they can enter into a prisons, whether or not they can use their own recording devices to perform interviews. The prisons impose a lot of limitations. For example, they limit the devices that are provided by the prison themselves for the interviews, but we're not able to guarantee that these recordings can be extracted from the devices, or maybe some recordings will be erased. We're not sure. And we don't know when the data is gone. Can the prisons restore the files? We are not sure. So I'm saying that the functioning of external inspection team is greatly restrained by the prisons. If prison management do not play along, then the external inspection teams find it very difficult to fulfill their duties. Furthermore, on the surface, external inspection team is composed of experts from different areas, but I have to say that most of the team members, in fact, are extremely unfamiliar with inmate and human rights. Many of them are not familiar with the Mandela rules, or they don't even know the Prison Act very well. So it's very difficult for us to expect that such an inspection team can perform proper inspection. Starting from last year, external inspection team members think that they don't have inspection or monitoring functions. They think they should play the role as the friend to the prisons, to help the prisons to make improvements. But in that way, they ignore their roles as inspectors. Finally, on Control Yuan and NHRC, I think they could have done better for inmate human rights. In fact, Control Yuan has a standing committee, that is the Judicial and Prison Management Committee. Control Yuan is able to perform unannounced visit to the prisons, actually, but in the past, they only visited 10 or 15 prisons a year. So from 2022 to 2024, they visited maybe 20 prisons, and each visit lasted less than 2 hours. And during such visit, they have never interviewed inmates to understand the realities of the prisons. Their inspections are quite formalistic. They listen to the presentations of the prison management, so that this judicial and prison management committee could have played a better role in inspecting, but in realities, they are not doing that.
In addition, according to the Control Act and the NHRC Organic Act, as we just heard, even though there's no implementation act of the CAT, the NHRC is still able to play the role of the MPM. So we hope that the Judicial and Prison Management Committee under the Control Yuan and the NHRC can do much more. While I protest, she has taken too much time. Actually, I think everyone should be given the same amount of time to make a point. Please treat everyone equally. I think she has taken too much of the time, and she actually is criticizing on an.
You ask for the floor and you get the floor, but don't simply interrupt, yes? The next one is the lady sitting behind you, and then I have 3 others. If you want to raise your arm, you can ask for the floor, but do it in a proper manner, please.
主席、各位委员。
Well, again, Chinese Human Rights Association speaking on the issue of the death penalty. Our association has been paying close attention to the human rights and the rule of law. We believe if we want to judge how much protection there is for human rights in a country, we should not depend on whether or not there is the death penalty. The same goes for the U.S. and Japan. They are considered as advanced countries in terms of human rights, even though they still retain the death penalty. How do we avoid wrongful convictions? While we need to rely on stringent judicial procedures rather than trying to abolish the death penalty. In fact, in the past 15 years, Taiwan has continuously decreased its number of executions. On average, 3 cases per year. In the past 5 years, there's only one execution. At the same time, there are increasingly stringent procedures taken. So I believe Taiwan has been implementing the right to life article under the ICCPR. As the opinion poll shows that 80% of the public are opposed to the abolition for years. And our association has conducted a large-scale opinion poll with the Taiwan Deliberative Democracy Society in 2024. Again, over 80% of the respondents disapproved of the abolition. The MOJ's latest opinion poll showed over 90% of the public is opposed to the abolition. So we want to protect the rights of the defendants. We also have to pay attention to the rights of the victims and their family members. According to the Constitutional Court number 8 of 2024, basically it says death penalty is conditionally constitutional. As a result, it's even more difficult for the court to give a death penalty sentence. And that is a constitutional court judgment. And it doesn't necessarily represent positive progress in our human rights development, because now, according to that judgment, it takes unanimous verdict to mete out a death penalty. In other words, one judge's vote may veto the other majority judge's decision, including citizen judge's decision. And I think this has distorted the legitimacy and fairness of the litigation procedures. This is judicial lawmaking, which may undermine people's trust in the judicial system. It also infringes on the legislature's right to make laws. So I hope in your concluding observations, you can take into account the opinion of the general public. Thank you.
I think you were the next, or if you know which was the order. Please.
Okay.
Yes.
The Taiwan Med Alliance speaking, some hospitals would admit people with mental disorders into the hospital, even though these patients do not try to hurt themselves or others. So this is against the patient's will. Chair, distinguished members of the committee, I speak on behalf of the Civil Human Rights Association. We are concerned about human rights violations in the psychiatric healthcare system. Maybe I can share with you some specific examples so that you know better what the reality is like in Taiwan and the gaps there. Based on the reports or information we received, a female was involuntarily admitted in 2024 in a hospital. She was mandatorily restrained, and she said she needed to go. And then two aides held her, and then a female nurse took her pants off and put on diapers on this female patient. This again constitutes cruel treatment. Another case happens also in Taipei in 2024. A woman was drunk and she didn't hurt herself or any other people. And then the police forced her to be admitted into a psychiatric hospital, and she was there against her will for 5 weeks. Another recent case happened in October 2025. A female in southern part of Taiwan, a slip of tongue, she missaid which clinic she was going to, and she said psychiatric, and then she was sent to a psychiatric hospital, and she was involuntarily admitted for treatment, and the hospital didn't inform her family or the place of her work, so everyone thought she went missing. Finally, they traced to the hospital, but the hospital did not release this patient, saying that this patient is a new case, so she has had to complete at least 14-day course of treatment, and she was prohibited from communicating or meeting visitors. We interviewed this patient. We found that she was involuntarily admitted. She was not told what rights she had, and she was forced to take medication, psychiatric medications 3 times a day, and she was also some strong medical shots were also injected on her, and there were some side effects on this patient. As a result, she was unable to walk freely. She was constantly dizzy. And I think these are violations of Articles 7 and 9 of the Covenant. This is not just a negligence of a single hospital. This is quite common in our psychiatric healthcare system. Moreover, there's going to be a new amendment to the Mental Health Act. We are concerned about this new amendment because they have to do with the judge reservation principle. Basically, according to the new amendment, the judge, a psychiatrist, and an advocate for the patient group can form a panel to decide whether this particular patient needs to be mandatorily hospitalized. However, according to the Ministry of Health regulations, this panel actually the patients, the family members, and the psychiatrist should form a panel to make a decision. In other words, the patient representative will be outnumbered in such a case. On informed consent, there's also room for improvement. We know that in 2023, the UN's guidelines on mental health, human rights, it's been emphasized that we should not rely on single biomedical model. Yet, that means more diverse alternatives should be sought after. But in Taiwan, we still rely on very single biomedical model to treat psychiatric patients. And very often, these patients are not informed about the potential side effects of the medications they are given. For example, they may become aggressive, suicidal. So I hope in your concluding observations, you can remind the Taiwan government to follow international human rights standards, especially in relation to involuntary hospitalization and treatment for people with mental issues, so that the human rights protection will be fulfilled not only in letter, but also in practice. Thank you.
Thank you very much. And may I perhaps repeat what your neighbor said before? There should not be too long statements so that everybody actually And have the floor, please. You're the next one. No, in the back there, first and then.
Okay, thank you. I'm from Amnesty International. I would like to highlight concern about the situation of refugees and asylum seekers in Taiwan under the Articles 7, 9, and 10. So we remain concerned about Taiwan's implementation of the administrative detention for migrants and asylum seekers. The current law doesn't set clear limits on how long people can be detained, and there are not enough safeguards to regularly review whether detention is really necessary or proportionate. So in practice, some people face prolonged and potentially arbitrary detention without timely and effective judicial remedies. So maybe our colleagues from Taiwan Association for Human Rights will share more on this. But from our side, Amnesty International is also concerned about Taiwan's implementations of the principle of non-refoulement. Taiwan still lacks comprehensive refugee protections mechanisms, so decisions involving refoulement or deportations are not consistently accompanied by individual risk assessment. So this means that there is no clear procedure to evaluate whether someone could face torture, persecution, or other serious human rights violations when they return to their country. At present, there are 12 asylum applications submitted by individuals from Myanmar have reportedly been rejected. And these individuals have been asked to leave Taiwan and return to Myanmar. Most of them are connected to families or organizations linked to dissidents in Myanmar. We believe that returning to Myanmar could place them at real risk of torture or other serious human rights violations. So we urge the committee to recommend that Taiwan establish a comprehensive refugee protection framework in line with the international human rights standards, strengthens the safeguards against arbitrary detentions, and fully uphold the principle of non-refoulement in both law and practice. Thank you.
Thank you very much. Please.
Hi, I'm from Prison Watch. I want to add more information on external inspection team. MOJ hires external team members, but as said earlier, the 51 prisons recommend who can be included in the team, and then the MOJ will make the selection. The candidates are proposed by the prisons, so the prisons, in fact, will screen out some candidates they don't prefer. Some budget or fees are decided by the prisons. So the prisons decide not only the candidates, they also pay for the fees for transportation and the compensation to the team members. And the inspection teams have to inform the prisons first before they make the visit, and that because they need coordination, so it's impossible for them to perform unannounced visits. And there should be some incentives for the team members to make unannounced visit as well. Because inmates may make complaints to the inspection team, but many inmates do not know how to reach out to the inspection team. If the inspection team have no ways of knowing what's happening in the prison, of course, they wouldn't have any incentive to perform unannounced visits. And that's a big problem for external inspection team. It does not have independence, because after a certain years, the team members will be changed. So the composition of the teams and how other agencies work with the team may all change. It's not a standing team, it's not independent, and therefore they cannot really perform true external inspection.
Thank you. The woman before, and then 1, 2, 3.
This is Taiwan Mothers Shield Alliance. I'll be brief. First of all, we need to attach importance to right to life. So I want to speak on behalf of the unborn children because their hearts are beating in their moms when they are born. They are alive and they shouldn't be let go through abortions. So in the cases that I serve, 70% or 80% of the women are willing to give birth to the children after some counseling. So I recommend that there should be a cool down period in our law, and to provide consultation and mentoring mechanism to the women so that they don't feel that abortion is the only way to go. Second, I want to speak for the government. In the public sector or in schools, there are gender-friendly toilets. And in the past several years, we see that there are hidden cameras which have been installed in these toilets which harm the women's safety. I think we need to pay equal attention to that. MOEA has allocated budget to build more gender-friendly toilets. And if the schools want to build such toilets, they can get such funding. But if they are just renovating the existing toilets, they don't have sufficient funding to do that. Thank you.
Campaigner of Taiwan Association for Human Rights, and I would like to add more information after Amnesty International. So before 2023, Taiwan did not provide any asylum-based residence documents for non-Chinese, non-Hong Kong, and non-Macau foreigners seeking asylum in Taiwan. Only until 2023, the National Immigration Agency publicly committed that cases would be reviewed under a dedicated mechanism if individuals could provide evidence indicating a risk of persecution. And if approved, the asylum applicants would be issued a temporary certificate called provisional alien registration card. And however, the ministry, the National Immigration Agency later reversed its position. It not only refused to clearly establish that the recipients of the alien registration certificate should include individuals protected under the international law principles of non-refoulement, but also refused to publicly explain the criteria actually used in approving or rejecting the applications. So during February this year, the Ministry of Interior gave it first decisions on the first batch of Myanmar cases, and the result was 0% approval rate. So the applicants are members of National League for Democracy, and also they are political activists and ethnic minorities fleeing from active military airstrikes. And none of them were granted status, and most of them were rejected for the reason of failing to provide concrete evidence. However, many applicants had already submitted substantial corroborating materials, including their party membership card and their legal summonses that they received from the Myanmar government, and also photographs documenting the destructions of their hometowns. And however, the NIA, the National Immigration Agency, appear to disregard the well-established reality in refugee protection practice that asylum seekers are frequently flee under emergency conditions, where carrying political sensitive documents may create then a significant danger. And at the same time, the authorities have never clarified what kind of evidence threshold is considered sufficient. And the NIA recently released a statement about their rejection. They argue that applicants who overstayed visa, who lost evidence, were called illegally and overstayed before they applying for protected, and this caused them did not qualify for protection under international standards. And however, before 2023, there was no legal document for asylum seekers to apply for, and we can see now that they claim that if the applicants are overstayed or they were caught illegally working in Taiwan, they should not grant protected. It's really violated the international principle of non-reformal that everyone should be protected regardless their residency status. And after the rejection, most applicants already filed an appeal. But even during the appeal, the NIA officers have been calling them and pushing them to leave. And they have been threatened that they will be send them back to detention center if they not leave after that. And not only after the rejection and during the review process, applicants are not granted any temporary legal status, and they are forced to live in a dangerous illegal status. And since they are not permitted to work, many are pushed into a high-risk informal labor market. And yes, thank you for this.
Thank you very much. Yes. No, there's another one.
Okay.
Taiwan Alliance to End the Death Penalty. In addition to what my colleagues said, there are wrongfully convicted cases like suits cases. I want to mention another case. That is the case of Mr. Wang Xingfu. Mr. Wang is the oldest death row inmate. He's 73 years old, but he is still being imprisoned in Tainan, in southern Taiwan. And many NGOs are having campaigns to support him. In addition to NGOs, the Control Yuan members also submit a report in 2024. They believe that Wang's case was a wrongfully convicted case, and this report pointed out all the problems around evidence and states that the country should study whether this case should be subject to extraordinary appeal. And the lawyers actually mentioned that extraordinary appeals should be given to him, but the retrials has been denied, and extraordinary appeals currently do not have any result. So when you draft your CORs, please mention this wrongful case of Mr. Wang. Additionally, on unanimous decision in the criminal procedure code, there are two systems. One system is the old system. The new system is the so-called citizen judge system. But in Judgment 8, there's no mentioning that unanimous decision should also be done in the citizen judge cases. Now, at the first instance, citizen judge cases, two have given death penalty sentence, and there are many violations of the confidence, I think. I want to add information. I need to say something. The so-called...
I have another request for the floor. 1, 2, 3.
Please.
好，主席。
This is Covenant Watch. I want to request you to remind the government, don't wait for the CAT to be approved before they start fulfilling the obligations under CAT. So there should be investigation on all suspect cases of torture, and otherwise the victims of the torture have the burdens of the proof. And in 2004, an inmate died in the prison because the judge said that he needs to apply the presumed innocence. So the judge says that we cannot say that there is any wrongful doing of the management of the prison, and if we do not actively initiate the investigation and the victims of the torture prosecutor will have the burdens of the evidence.
And also, the state should take the initiative to start an investigation into a non-natural death in prison. Even though it may seem like a person who died from a natural cause. For example, recently there's a death row inmate who died from complications of diabetes. But I think the state still needs to intervene and investigate to make sure that there's no negligence on the part of the health care provided by the state. Thirdly, the state should also look into the long-term care facilities and wards to see if there are any cruel or inhumane or degrading treatment.
We are coming to an end.
I need to say this, please.
Yes, please. The next one and then he.
Okay. 我想要
But try not to be too long.
Okay. 30 seconds, please. 首先我
First of all, I would like to say the so-called wrongful conviction. This is some assumption or presumption some people take. We should not try to, justify the exceptions. After all, there are certain risks we have to be aware of. There are procedural justice that's already being validated. Again, I want to protest strongly what they said. Mr. Chiu and the two cases involving citizen judges, as well as the cases that are still under trial, you're not supposed to comment on those cases since the trial is still ongoing. You are not allowed to interfere in the Taiwan judicial system. Otherwise, you can be the president, the premier, the president of the judicial yuan, or the prosecutor general. Okay, first of all, you should not interfere in any trials that are still ongoing. Secondly, the death row inmates and the death sentences, actually, the Taiwan judicial system has made the final judgments and decisions. So as the president of the National Association of Equality for Life Taiwan, I don't think you should include in your concluding observation the opinions you just heard from those groups. And I protest strongly. In fact, I have been receiving text messages from the families of victims. They want to express their strong protest. Do not include in your concluding observations your views on any trials, on any cases that are still going through the trial phase. Thank you. What I want to say is there are many cases that person referred to. Yes, there are final decisions and rulings. However, these people are only filing for extraordinary appeals.
I mean, we have to close it. Sorry, we still have 10 minutes. So, and do we have 1813, 30 or 20?
20.
20. Okay, then we have to stop. I just wanted to ask the members of the committee whether you want to have some kind of final observation, please.
Thank you all for your views. One would have the impression that there's a lot of disagreement in the room, but we actually, I think, probably all agree on some fundamental things. First of all, we all cherish the right to life. Those of you who are arguing for the death penalty are doing it because you say it's a punishment for people who take human life. I think we also all agree that victims are entitled to justice, and this is as much a part of human rights law as is the protection of the rights of the defendant. I'm sure we also agree on the fact that we don't want to see innocent people executed or punished. I'm sure we agree on that. You may disagree on the people who are affected by that, but you would agree. I'm not going to go over my views again. You heard me, I think, earlier today, or you know them, and you can see them on the internet if you're interested about capital punishment. I think it's inevitable that it's going to disappear. This has been the pattern in history in human rights, and so I think if you have difficulty accepting it, you should get used to the idea. I'd say one other thing. Public opinion has been invoked as a justification for retaining the death penalty. And I also expressed the view that I have my doubts about the reliability of the studies of public opinion that have been done. I think that a well-informed public, given a reasonable choice between taking another life and punishing someone appropriately with a term of detention, is going to reject the idea of capital punishment. That's my view, and I expect that sooner or later public opinion surveys will demonstrate that. And I would like to think that people who base their justification of the death penalty on public opinion polls will be prepared to accept such a view if public opinion polls indeed show what I think they will show, and that you will change your mind.
Thanks very much. Then this concludes our discussion on Article 6 to 11. Again, many thanks for all your active participation, even if there are fundamentally opposing views. That's part of civil society. We have listened very carefully, and we will certainly take many of your statements and opinions into account when we draft our final observations and recommendations. But I think I want to stress that we are a panel of independent experts. We are bound by interpreting international law. So we are not getting into political disputes. It's simply a legal assessment of Taiwan's compliance with its voluntarily accepted obligations under international human rights law. So please keep that in mind. Thank you very much and have a nice evening.
That concludes today's review meeting. Tomorrow, we're going to reconvene at 8:30. Thank you for your participation.